Hello, good morning, and welcome to Byju's Exam Prep. Yesterday, we initiated a discussion on fundamental rights. Fundamental rights are those basic, important rights which are necessary for the growth, development of an individual. Without these rights guaranteed by the Constitution, an individual cannot explore his potential to the maximum capability. Now, these fundamental rights under Part 3 of the Constitution, there we have to discuss Articles 12 to 35. Article 12 talks about the definition of the state. For example, throughout this lecture on fundamental rights, we will come across this term known as the state, against which you can claim your fundamental rights. So if the state is violating your fundamental rights, you can approach the court, knock the doors of the court, and the Supreme Court is the guardian of your fundamental rights. Then Article 13 is a simple article which basically says all laws prior to the commencement of the Constitution, these laws, if they agree with Part 3, if they are in agreement with Part 3, if they are in conformity with Part 3, these laws will continue. If these laws violate fundamental rights, then these laws shall be declared null, void, unconstitutional by the judiciary. But can we delete a fundamental right? Can we modify a fundamental right? Can we abridge a fundamental right? Yes. But that cannot be done through an ordinary law. That cannot be done through an ordinance. That cannot be done by an executive by issuing a rule or a notification. That can only happen if the Parliament enacts a law under Article 368 of the Constitution, which you would know is slightly difficult because it requires special majority. Clear? Now let's look at fundamental rights in great detail. We'll start with first category of fundamental rights, right to equality. And there we'll have to discuss Articles 14 to 18. We'll look at Article 14, then 15, then 16, then 17, then 18. Then right to equality category is over. Then we will look at right to freedom. Then we will look at right against exploitation. Then we will look at right to religion. Then we will discuss cultural and educational rights. And at the end, we will discuss right to constitutional remedies. Shall we start? Let's look at Article 14 of the Constitution. Article 14 basically talks about two things. What are these two things? The state, and now you know what is the definition of the state. The state shall not deny to any person, which means we are not talking about citizens only. We are talking about aliens as well. That means this fundamental right under Article 14 is available to anybody who is within the territory of India, whether you are a citizen or you are a foreigner. The state shall not deny to any person what? Equality before law and equal protection of the laws within the territory of India. Within the territory of India, the state shall not deny two things: equality before law or equal protection of the laws within the territory of India. Now, equality before law and equal protection of the laws may appear similar, may sound similar, but there is a difference, and there is a vast difference. And what is the difference? Equality before law or equal protection of the laws, they do not mean same treatment to everyone. If we give same treatment to everybody, it will lead to an unequal treatment. Unequal treatment in the sense, very simple. There is a class, and in the class there are 100 students. All these 100 students are different. Some would need more hand-holding, some would need more explanation, some would need more care, more attention. Now, if there is a teacher in the class who is giving equal attention to all the students, then this would result in an unequal treatment, because you are giving same amount of attention to a topper, same amount of attention to somebody who is weak in your particular subject. If you give same attention to everybody, although it might appear equality, but it is not equality, it leads to an unequal treatment. That is why those who are similar can be given similar treatment. That means all the toppers can be given a different set of treatment. All those who are weak in your particular subject may be given different level of treatment, maybe more hand holding, maybe an extra class, maybe an extra attention, maybe an extra doubt resolution session. And that is the underlying principle behind equality. To make it clear, first we will look at what is equality before law, then we will look at equal protection of the laws. If we look at equality before law, we have borrowed it from the UK Constitution. And it is considered to be the corollary of A.V. Dicey's concept of rule of law. What is corollary? If you have studied mathematics in your 10th standard, which I'm sure you have, corollary means if there is a statement given, by reading the statement, by understanding the statement, what is the immediate inference that you can draw? What is the immediate conclusion that you can draw from the statement? That is what we call corollary. So what is this equality before law? To understand equality before law, we need to understand what is rule of law. By understanding rule of law, we will come to understand what is equality before law. Although this rule of law as a concept was given by different political theorists, Aristotle also talked about this, various other experts talked about this, but there is one British constitutional expert called A.V. Dicey who has crystallized this concept, who has given more shape to this concept, who has more elaborated this concept. And what is this rule of law? There are three principles. One, no person shall be made to suffer in body or goods except for a breach of law. If I have not committed any crime, why should I be arrested? Why should my body be detained in a prison, in a jail? If I have not committed any crime, if I have not snatched the law of the land, if I have not snatched the land of the government, if I have not snatched the government land, if my property is on my land, not on the state land, why should my property be snatched from me? Which basically means no person shall be made to suffer. Nobody should be detained. Nobody should be arrested. No one's property should be confiscated. No one's property should be snatched and deprived from him unless and until you have violated a law. This was a system prior to the rule of law's emergence in Europe, for example, in Britain, for example, where if you are from a particular color, for example, you are brown, you're black, you're not fair, you're basically not from the white race, you were detained, you were arrested, your land was snatched, your property was snatched. After rule of law came into being, it was made clear that unless and until you have violated a law, no matter who you are, what your ethnicity is, what your race is, what your religion is, what your language is, what your gender is, unless and until you have violated a law, your land cannot be snatched, your property cannot be snatched, your dignity cannot be snatched. You cannot be arbitrarily detained. And what is this arbitrariness? We have discussed in the previous class. Right against arbitrariness is a fundamental right under Article 14 of the Constitution. So arbitrarily, you have not committed any crime, but based on the whims and the fancies of the police, you are being detained. You are being arrested. You have not committed any crime. You have not snatched the public property. Even then, your property is snatched from you. This cannot happen when the rule of law is in place. So what is rule of law? No person shall be made to suffer in body or goods. In a sense, nobody's body shall be detained. Nobody's property shall be confiscated unless and until you have violated a law, you have breached a law. Number two, a person can sue or be sued. Only blacks, against them case can be filed, or against whites also the case can be filed. Only the men can file a case, not the women. Only the member of the upper class can file a case and not the members of the lower class. Only those who possess property can file a case, Those who don't possess a property cannot file a case. Only those who are educated can file a case, and those who are illiterate cannot file a case. That doesn't happen when rule of law is in place. Anybody can sue or be sued. Anybody can file a case against anybody. If you think that these individuals have violated your rights, violated your dignity, violated your property, that means right to knock the doors of the court is available to everybody, regardless of your gender, regardless of your race, regardless of your language, any other consideration. And A.V. Dicey says rule of law also means constitution is the result of the ordinary law of land. But sir, previously you said constitution is the supreme law of land. Now you are saying constitution is the result of the ordinary law of land. For that you need to understand that this concept, rule of law, is coming from A.V. Dicey. A.V. Dicey is a British constitutional expert. And in Britain, UK constitution makes it clear that it is the parliament which is sovereign. It is the parliament which is supreme. Constitution is not supreme. Parliament can do anything except convert a man into a woman and a woman into a man. That's what the Constitution of UK empowers the Parliament of UK. Parliament of UK is sovereign. That is why A.V. Dicey says in rule of law, when a law is passed, it is basically at the discretion of the Parliament. Parliament can pass any kind of law. But in India, we say Constitution is not the result of the ordinary law of land. Constitution itself is the supreme law of land. So what is Article 14? The state shall not deny what? Equality before law or equal protection of the laws within the territory of India. What is equality before law? We have borrowed it from the UK Constitution. But what is it? It is basically the corollary of A.V. Dicey's concept of rule of law. And what is this rule of law? No person shall be made to suffer in body or goods except for a breach of law. A person can sue or be sued. And the law making is the job of the Parliament. Parliament can pass any kind of law, and through this law, only this law will be operational. And through this law, it can provide rights to the people of a particular country. Before rule of law, the position was Rex Lex. And after rule of law came into being, the position changed and it became Lex Rex. And what is this Rex Lex? King is the law. Whatever king says, that becomes the law of the land. But now, when king, whatever he says becomes the law of the land, but king can today pass a law, tomorrow repeal this law. King can today say whatever he has to say. He is the judge, jury, and the executioner. That means an individual gets to decide whether a particular system is to be put in place or should be dissolved. After rule of law came into being, we say law is the king. And everybody has to follow this law, including the king. And everybody has to abide by this law. And through this law, you cannot deprive people of their rights. Through this law, you cannot discriminate against people. Through this law, you have to treat everybody equally. And that is what we call equality before law. But sir, it is still not clear. Let me make it even more simpler. In simple terms, what is rule of law or what is equality before law? Number one, absence of special privileges. No matter who you are, there will be no special privileges given to you by the law. Law is same for everybody. No special privilege for the Prime Minister. No special privilege for a minister. No special privilege for other sections of the society. Everybody is to be treated equally. The law will not discriminate, will treat everyone equally. Second, equal subjection of all laws, equal subjection of all persons to the ordinary law of land. If you have committed a crime, let's say murder, No matter what religion you belong to, what caste you belong to, what gender you belong to, what region you belong to, what language you speak, what dress you wear, what food you eat, doesn't matter. All of you will be booked under Section 302 of Indian Penal Code. That means this law, which talks about punishment for murder, it will not discriminate against any person. No matter who you are, if you have committed murder, all of you will be booked under the same provision, same law. It doesn't mean that if a Brahmin commits a murder, you will be booked under a separate law. If a Dalit commits a murder, you will be booked under a separate law. And for this separate law, you will be given death sentence. And for this separate law, you will just be given a fine. That cannot happen. Equal subjection of all persons to the ordinary law of land. And third, no person is above the law. No person, no matter who you are, is above the law. You have to abide by this law. Law is supreme. And that is what we call equality before law. So what is equality before law? It basically means no special privileges, no matter who you are. Equal subjection of all persons. All people should be subjected to the same law. Same law regardless of any discrimination. And nobody is above the law. But when we say nobody is above the law, there are some exceptions. Which means equality before law as a fundamental right is not absolute. There are some exceptions. When we say nobody is above the law, there are some exceptions. When we say equal subjection of all persons to the ordinary law of land, there are some exceptions. When we say no matters who you are, no special privileges will be given to you, there are some exceptions. And which are these exceptions? President and the governor. When they discharge their duties, they are not answerable to any court of law with regards to their official functions. What is their official function? For example, president has the power to sign a bill which is passed by both houses of the parliament. You cannot drag the president to the court and say, why did the president sign this bill? Why did the president not sign this bill? Why did the president say, I'm not going to sign this bill? President or the governor is not answerable to any court of law in this country with regards to their official functions. Why? Because there is a convention in Britain. What is the convention? We have to protect the dignity of the office. Of the king or queen. For example, the governor, on the advice of the chief minister and council of ministers, can promulgate an ordinance. And we will discuss later what is an ordinance. Ordinance is basically a temporary law, and we will discuss. You cannot approach the court and ask the court, why did the governor issue this ordinance, promulgate this ordinance? That cannot happen. Because when we say law is equal for everybody, no special privileges, no matter who you are, there are some exceptions. Because Article 14 is not absolute. When we say Article 14 is absolute, if we say Article 14 is absolute, that means there are no exceptions. This is a fundamental right for everybody, regardless of any exceptions. But Article 14 is not an absolute fundamental right. It comes under exceptions. Sir, can you make it still clear, even clear, what are these exceptions? For example, in previous classes, I've told you, all the citizens have the freedom of speech and expression. That's what the Constitution says. But the same Constitution imposes restrictions on your fundamental right to free speech. Yes, you can say whatever you have to say, but you cannot violate public order. You cannot incite people to violence. Those are what we call restrictions on your fundamental rights. That means Article 19 is not absolute. If Article 19 was absolute, you could have said anything. Even incited people to violence, even violated public order, even defamed the judiciary, even committed contempt of court, even defamed you, me, or anybody. But right to free speech is not an absolute fundamental right. There are exceptions. Similarly, Article 14, when we say nobody is above the law, there are exceptions. And which are these exceptions? President or the governor. They're not answerable to any court with regards to their official functions. Number one. Number two, no criminal action whatsoever can be initiated against the president or the governor so long as they remain in the office. That means, can the president or the governor of a state commit murder and no case can be filed against them? Yes. Can they commit rape or dacoity and no action can be taken against them? Yes. Why? Because they follow, or we follow, something which is prevalent in Britain, a convention which is prevalent in Britain, which says king does no wrong. When king does no wrong, that means no criminal action can be taken against the president or the governor while they remain in office. For example, we had governor of Rajasthan. He was previously the chief minister of Uttar Pradesh as well. His name was Kalyan Singh. Now, unfortunately, he has passed away. Kalyan Singh was the chief minister of Uttar Pradesh at the time when Babri Masjid was demolished in Ayodhya. He had given an assurance before the court, before the Supreme Court. When the Rath Yatra was started by L.K. Advani, when these car sevaks, they were traveling to Ayodhya and they wanted to destroy Babri Masjid so that on the ruins of Babri Masjid, a mega Ram temple can be constructed at Ayodhya, because there was a belief that Ayodhya is the birthplace of Lord Ram. When these car sevaks were moving closer towards Ayodhya, towards Babri Masjid, matter went to the court. The court sought an assurance from Kalyan Singh. Kalyan Singh said, we will ensure that nobody will destroy Babri Masjid. Nothing will happen to the structure. We will protect it. But he failed to protect. And ultimately, in December 1992, the Babri Masjid was demolished. Then a case was filed against Kalyan Singh on the grounds of contempt of court. Also on the grounds of criminal conspiracy. What is contempt of court? There are various meanings of contempt of court. I'll just tell you one meaning right now. When you give an assurance to the court, when you give a representation before the court, and if you backtrack, if you fail to abide by that, that means you have disobeyed the court. If Mr. Kalyan Singh had conveyed before the Supreme Court that I will protect this structure known as Babri Masjid, and since you have failed to protect this structure, which means you have disobeyed the court, which means you are liable to be punished for committing contempt of the court. This was charge number one. Charge number two was criminal conspiracy. It was argued that Mr. Kalyan Singh is responsible. He has conspired in such a manner that people will come out in large numbers and destroy the structure. So two cases of contempt of court, criminal conspiracy was filed against Kalyan Singh. And this matter continued for a long time. And then Kalyan Singh was appointed as the governor of Rajasthan. And when he was appointed as the governor of Rajasthan, Mr. Kalyan Singh enjoyed immunity. What is immunity? There is COVID-19 virus. And then we have the COVID-19 vaccine. Whether it is from Pfizer, whether it is from Serum Institute, whether it is any other vaccine. What is the purpose of this vaccine? To give you immunity. So that even if the virus attacks you, your own immune system will fight against the virus, you will not fall sick. That's what we call immunity. Similarly, Kalyan Singh got immunity. When he was appointed as the governor of the state of Rajasthan, he enjoyed immunity because no criminal action can be taken against the governor or the president so long as they remain in the office. That means for these 5 years, when Mr. Kalyan Singh was the governor of Rajasthan, no action was taken against him. You can say this case stopped for these 5 years when Kalyan Singh was the governor of Rajasthan. Only after the term of Kalyan Singh got over, then the case continued against Kalyan Singh, and later on the court said you are not guilty, you are innocent, you are set free. But what is the point here? When we say rule of law, when we say equality before law, when we say nobody is above the law, when we say no special privileges, no matter who you are, this fundamental right is not absolute because there are exceptions. What are these exceptions? President and the governor, while they are in office, no criminal case can be filed against them. Number one. But after they cease to remain in office, after their term is over, cases can be filed against them. One. Second, while they are in their duties, while they're discharging their duties, in their official capacity, whatever they do, they are not answerable to any court of law. Similarly, foreign diplomats, heads of the foreign countries, they are not answerable to the courts of India in discharge of their official functions. For example, we have Vienna Convention on Diplomatic Relations. Vienna Convention on Diplomatic Relations, 1961. And this was the product of Cold War. What is Cold War? After Second World War got over, the world became bipolar. Two superpowers emerged on the world map. One, USSR, the other, US. There was a lot of hostility between these two countries. And it was argued in the 1950s, 60s, 70s, 80s that at any point in time, US and Russia will go to war. Without firing a single bullet, there was always this apprehension that these two countries will go to a war. So there was no actual war, but there was this entire hostility that we always thought that there will be a war, if not today, but tomorrow. That is what we call Cold War. It was not hot because no bullets were fired, no missiles were fired, no magazines were fired, but it was Cold War. And during this period of Cold War, Russian diplomats in other countries which are closer to US would kill them. US diplomats in other countries which were closer to USSR, US would kill them or detain them or pressurize them or subjugate them to torture. Now, the need was felt that we need to protect these diplomats. IFS officers, for example, posted in Germany, posted in Japan, posted in United States, you should be in a position to do your job without any fear. So if you are sent to a country, for example, you are sent to Germany, in Germany you could not be arrested. In Germany, you are allowed to work without any fear that German police will come and arrest you, will detain you, will file a case against you in the court of Germany. That immunity is given by Vienna Convention on Diplomatic Relations. That means a foreign diplomat posted in India, no matter what he or she does, can they commit rape, murder, dacoity, terrorism as well, anything, and no action can be taken against them because they enjoy immunity under Vienna Convention on Diplomatic Relations. But does that mean, or for that matter, few years ago, there was a Saudi diplomat in Delhi who was residing in Gurgaon. He would bring girls from Nepal or women from other parts of India, and allegation is he would sexually assault them, molest them, rape them. No action was taken against that diplomat. He was not arrested either. Why? Because they enjoy immunity under Vienna Convention on Diplomatic Relations. What if a Pakistani diplomat does the same thing? Indulge in terrorism in India, indulge in violence in India. Can we take any action against that diplomat? No. The only thing that we can do, the government of India can do, can declare that diplomat as persona non grata. So if there is a Pakistani diplomat who has indulged in terrorism, who is giving money to the terrorists, we know he is violating the law of the land, but we can't do anything because he enjoys immunity under Vienna Convention on Diplomatic Relations. What we can, however, do, we can declare that person as persona non grata, which basically means we will give him time. Can be 12 hours, can be 24 hours, can be 48 hours, can be 72 hours. And within this time period, you have to leave this country. If you don't leave this country, we are going to arrest you, detain you, and case will be filed against you. And that is how few years ago, some of the diplomats from Pakistan were declared as persona non grata, and they had to quickly leave this country. But we don't have to discuss that because that comes under international relations. We have to discuss related to polity. And what is that discussion? Although there is equality before law, but this fundamental right is not absolute. There are exceptions. Exceptions such as president, governor, exceptions such as visiting heads of foreign countries and foreign diplomats. For example, when Mr. Modi, as the Chief Minister of Gujarat, when he was accused of turning a blind eye towards the riots in Gujarat, then United States banned Mr. Modi from entering United States. So he was banned from entering the United States. But then when Mr. Modi came to power, then there was a question before the US authorities, how should we deal with Mr. Modi now? Maybe somebody would file a case in United States court and ask the Supreme Court authorities in US to arrest Mr. Modi. Then the US clarified that Mr. Modi, since he is the head of a government, he enjoys complete immunity. No action can be taken against him while he is in United States. So similarly, if, for example, there is a individual who is a wanted individual, who is a terrorist, but he is becoming the head of the state of Pakistan, when he enters India, he enjoys immunity. Immunity in the sense he cannot be arrested, he cannot be detained. To make it even simpler, if tomorrow Pakistan elects Hafiz Muhammad Saeed as the Prime Minister of Pakistan, he is wanted in India. But if he travels to India on a visit, we cannot arrest him, we cannot detain him because he would enjoy immunity because he is the head of a country. So equality before law, but there are some exceptions. Is that clear? Any questions as of now? Good. Now, what is then equal protection of the laws? We say equal protection of the law is a positive concept, and we have borrowed this concept from the United States of America. And to understand equal protection of the laws, let's take a look at this picture. Let's take a look at this image. There are three people who are trying to watch a baseball match. Person A, B, C. And from the distance, state is watching them. What is a state? State under Article 12 of the Constitution. The state is not discriminating. The state is giving them equality. What the state has given them? A tool on which the three people are standing and they're able to watch the match. Is the state practicing something called as equality? Yes. What is equality? Equality basically means that the state will not discriminate against any person. The state will treat everybody equally. So if these three individuals, they wanted to watch a match, a baseball match, all of them are given this tool of similar quality, similar size, similar length and breadth and weight, similar treatment, equal treatment. But when we give equal treatment in this situation, but give equal treatment in a situation which is not equal at all, this person is able to watch the match clearly. He is not even needing this tool. This person is also able to watch the match clearly. But this person is unable to watch the match at all. He is struggling to watch this match. And the state is hands off, is not interfering at all. State says we are practicing equality. We are giving them equal treatment. But if you give equal treatment in an unequal circumstance, it is not equality. It is not justice. It is not what we call equity. Now, if the state is now discriminating, In this situation, the state has to discriminate. But that discrimination is what we call positive discrimination. And what is this positive discrimination? The state is removing this tool and is giving to the person C. Now, person C is given two stools to stand on. Person B is given one. Person C is not given anything. Is this equality? No. But is this justice? Yes. So equality plus justice is what we call equity. Because these were not similar. Now they are made similar. When the state is discriminating, but positively discriminating, and it results in the treatment which results in justice, this is what we call equal protection of the law. For example, all the people of this country given equal opportunity to get a seat in an educational institute or get a job in a government sector. If we treat all the people equally, just like this, and the state says, see, we have 10,000 seats in educational institutions, we are throwing these seats open to anybody. Whoever wants to come can apply for these seats. We will not discriminate. And we will ensure that anybody, regardless of your religion, race, caste, sex, place of birth, can apply for these seats. And there are jobs which are released by the government. For example, UPSC advertises posts for the civil services examination. The state is saying we will not discriminate against anybody. Whoever wants to apply for this exam can apply for this exam. Results will be declared. Whoever will come under top 1100, we will give them a place, we will give them a job in the examination. The state is not discriminating. Is this equality? Yes. But what about members of the Dalit community? What about SCs and STs and OBCs who have been discriminated against throughout the history? I gave you the instances of untouchability, which was prevalent during the colonial period, even before that as well. This practice of untouchability, some experts argue, some writers argue, started after the later Vedic period. So after later Vedic period, there was this intense discrimination against the members of the tribal community and the Dalit community. And because of that, they were not allowed educational opportunities. They were not given employment opportunities. So they were never equal. When they were never equal, never treated as equal, first we have to give them something. First we have to positively discriminate. Give them a reservation in jobs, reservation in educational institutions. That means this tool can be a reservation for the members of SC, ST, OBC community or economically weaker sections of the society. That is how we can create justice in the society. Because no two individuals are the same. If we have to treat everybody with equality, it will result in an unequal treatment. What is this unequal treatment? I'll give you one more simple example. You don't like my class. And suddenly what happens? You try and enter through the camera and you kill me. Stab me in my stomach and I'm dead. My father will file a case against you. Now you will argue before the court of law, my lord, there is equality under Article 14 of the Constitution. You have to treat me in the same fashion as you're treating the victim. But can a victim and a criminal be treated equally? If indeed we practice equality, that means we have to treat a victim as well as the persecutor equally. That will result in an unequal treatment. So victim will be given compensation. The murderer will be given death sentence. That is justice. So we are treating all the victims similarly. We are treating those who are in dissimilar situation separately. That is equal protection of the law. An equal protection of the law, in simple terms, that among the equals, the law should be equal and equally administered. That like should be treated alike, which means all the Dalits can be treated alike. Within the Dalit community, you cannot discriminate. That you are Dalit, but you are women, we will treat you separately. You are Dalit, but you possess property, we will treat you differently. You are a Dalit, but you have political connections, we will treat you differently. No. If you are one group, which is Dalit group, all of you are to be treated equally. All the Dalits are to be treated equally. But Dalits cannot be compared with the Brahmins. If we compare them together, if we treat them similarly, it will result in an unequal treatment. It requires what is known as the affirmative action by the state towards unequals by providing them facilities and opportunities. Reservation is what we call affirmative action policy of the government. We affirm, we recognize that yes, you have been facing discrimination throughout the history. And now what we will do, we will give you more opportunities. We will give you more facilities. We will give you more opportunities, more facilities, so that you are brought at the same level as the other members of the society. And once everybody is equal, then we can talk about equality. That means the principal purpose of Article 14 of equal protection of the law is substantive equality, is distributive justice. What is substantive equality and distributive justice? There are marginalized sections of the society. There are weaker sections of the society. There are disadvantaged sections of the society. We have to give them more. When we give them more, that means we are denying equality to others. We are not treating all of them equally, but we are giving more to the weaker sections of the society, marginalized sections of the society. That is what we call substantive equality. That means we are giving more to those who are unequals. And we are distributing resources, facilities, more in favor of the weaker, marginalized sections of the society. That is the whole point of Article 14. And this different treatment is, for example, progressive taxation. Tomorrow or a few days ago, when the union budget was presented, there are different tax slabs. If you're earning up to 2.5 lakh rupees, if you're earning from 2.5 to 5 lakh, or now 7 lakh under the different tax regime, if you're earning up to 10 lakh, if you're earning up to 20 lakhs, if you're earning more between 50 lakhs to 1 crore, if you're earning between 1 crore to 2 crore, if you're earning 2 crore or more, additional surcharge, additional tax. Can somebody approach the court and say, why 30% tax on me plus 14% of surcharge, and why no tax on others? The court will reject this petition. What are you saying? This is progressive taxation. And this is justified by Article 14 of the Constitution. Likes are to be treated alike. Unlikes cannot be treated alike. We are saying all those who earn above 2 crore rupees, you have to pay additional surcharge. We are not discriminating there. We are not saying for women something else, for men something else, for Dalit something else, for Brahmin something else, for Hindu something else, for Christian something else. We are treating all those who earn above 2 crores equally because they are likes. But we cannot compare those who earn 2 crores with somebody who is earning only 2 lakh rupees. Is this equality? This is substantive equality. Similarly, armed forces are allowed to possess and consume liquor in prohibited areas. Why? Because they have to defend this country. They are working, guarding our territory away from their families. So we need to give them special protection. We need to give them special avenues so that they can kill the boredom. That is why they're allowed to possess and consume liquor even in a prohibited area. And that is justified under Article 14 of the Constitution. Long story short, right to equality as a category. There we have to discuss Articles 14 to 18. Article 14 says the state shall not deny. We know what is a state, who is a state. This state cannot deny. What it cannot deny? Equality before law or equal protection of the laws within the territory of India. Although these two terms, these two phrases may sound similar, may appear similar, but they are different. Different in the sense, equality before law is negative concept. Equal protection of the laws is a positive concept. Why equality before law is negative concept? No special privilege no matter who you are. Equal subjection of all laws. No matter who you are, you're not above the law, but there are some exceptions. President, governor, visiting heads, foreign diplomats. But equal protection of the laws is a positive concept. We have to give more to those who belong to weaker sections of the society because we have to ensure substantive equality. So it's a positive concept where the state is interfering. And the state is interfering to give more to some who belong to weaker sections of the society, to give nothing to those who are already well off. So this distribution makes it justice. And that is at the heart of equal protection of the laws. That is Article 14 of the Constitution. Any questions? Then we will jump to Article 15. Is Vienna Convention applied to every country, for every country's diplomats? Whoever is a party to Vienna Convention, it will be applicable to them. And there are close to 163 countries who are part of Vienna Convention, or I think 194 countries which are part of Vienna Convention. Not same punishment for adult and child. That is treating different people differently. You cannot treat an adult in the same fashion as child is. Yes, India is a signatory to Vienna Convention. Okay. Now let's look at Article 15 of the Constitution. And in Article 15, we will have to discuss 6 clauses. 15, Clause 1, Clause 2, Clause 3, Clause 6. But don't try to memorize all these clauses. Just understand the concept behind Article 15. And what is Article 15? Article 15, Clause 1 says, the state shall not discriminate against any citizen. And now we are specifically talking about a citizen. That means this fundamental right is exclusively available to the citizens. Article 14 is available to any person within the territory of India, which means foreigners as well as citizens. But Article 15 is specifically targeted at the citizens, provided to the citizens of India. It says the state, and we know who is a state, the state shall not discriminate against any citizen only on the grounds of religion, race, caste, sex, place of birth, or any of them. That means the state cannot discriminate. On which grounds? Only on the grounds of religion, race, caste, sex, place of birth. Which means, can the state discriminate? Can the state discriminate? Yes. But then on what grounds? On 6th ground. On 7th ground. On 8th ground. On nth ground. On the basis of which valid discrimination can be made. What is that valid discrimination? Here is an individual who is trying to apply for an educational seat in Jawaharlal Nehru University, JNU, anti-national university, some would call it. But humor aside, you want to apply and get a seat in JNU. Clear? The university authorities deny it. You will not be admitted. You're aghast, angry. Is JNU a state within the meaning of Article 12? Yes. Why? Because number one, it has been created by the state. That means it's a government institution. When it's a government institution, that means it is owned by the government, which basically means it is a state under Article 12. And now you are dragging JNU to the Supreme Court. My lord, JNU has violated my fundamental rights. The Supreme Court says, JNU again? Okay, let's hear this case. Why do you think that JNU has discriminated against you? Sir, they have denied me admission because of my religion. Because I come from this religion, that is why they have denied me admission. Another person would come, sir, me too. They have denied admission to me as well. Why? Because I come from a particular caste. That is why they have denied me admission. Another said, sir, me too. Because I come from a particular race. I come from a tribal area. That is why they have denied me admission. Sir, me too. Because I'm a woman. That's why JNU has denied me admission. Sir, me too. Because my place of birth is Northeast. My place of birth is Tamil Nadu. My place of birth is Gujarat. They say that you are from Gujarat, you're closer to Mr. Modi, you're closer to Mr. Adani, we will deny you admission. On these grounds, admission has been denied to us. My lord, you are the protector, guardian of our fundamental rights. Please ensure that our fundamental rights are given back to us. Supreme Court will say this is a serious matter. JNU, please come. Why are you discriminating against these people on the grounds of religion, race, caste, sex, place of birth? JNU says, yes, we are discriminating. Said, really? Yes, sir, we are discriminating. But not only on the grounds of religion, race, caste, sex, place of birth. So we are not concerned about their religion, race, caste, sex, place of birth. On these grounds, we are not discriminating. Then why are you discriminating against them? Sir, on the grounds of age. Look at their age. His age is 10. Her age is 12. And to get admission in a postgraduate program, you should be 18 plus. So on age, we are discriminating against them. But what about that lady? She says on the grounds of sex, you have discriminated against her. I said, no, sir. We have discriminated against her, yes, but on the grounds of merit. She failed the entrance test. Now she is saying, you have selected 200 people who have been selected because of an entrance test. She failed that test. Look at the results. How can we give her admission? Yes, we are discriminating, but not on the grounds of sex, but on the grounds of merit. That means the state can discriminate, but only on the grounds of religion. Just because of your religion, race, caste, sex, place of birth, or any of them, the state cannot discriminate. That is Article 15, Clause 1. The state shall not discriminate against any citizen only on the grounds of religion, race, caste, sex, place of birth. That means here, if you are from a particular religion, only on the grounds of religion, no. On the grounds of age, you can be discriminated. Only on the grounds of caste, no. On the grounds of merit, you can be discriminated. That is Article 15, Clause 1 of the Constitution. But Constitution makers also realized that when we look at fundamental rights chapter, we say these fundamental rights are claims against the state. When the state is violating your fundamental rights, you can claim your fundamental rights against the state. But the makers of the Constitution also realized that people of this country also deserve to be on a different level. They also need to be very, very careful. Why? Because it is not only the state which cannot discriminate. It should be the citizens also. They should also not discriminate against fellow citizens. How? If you are from Dalit community, this well, you cannot drink water from this well. If you are from Dalit community, I will not give you medicines from this shop. If you are a woman, I will not allow you to enter the, let's say, a burial ground or a cremation ground. That means it's not only the state. To ensure justice in the society, we need to prevent citizens discriminating against other citizens on these grounds. That is why Article 15 Clause 2 says, no citizen shall be discriminated only on the grounds of religion, race, caste, sex, place of birth. It is not saying the state shall not discriminate. It is saying no citizen shall discriminate. That means this Article 15 Clause 2 is available against citizens as well. So if a citizen is discriminating against you only on the grounds of religion, race, caste, sex, place of birth, you can drag that citizen to the court. In what matters? When you are trying to access shops, public restaurants, hotels, or places of public employment. When you are trying to access the use of wells, tanks, bathing ghats, roads, places of public resort. When you are trying to access public property, then there can be no discrimination. A fellow citizen cannot discriminate against you. But you might say, sir, I have attended your class. Now I will enter your house. You cannot discriminate against me. Why? Because you cannot discriminate only on the grounds of religion, race, caste, sex, place of birth. Citizen also cannot. I said, my dear, don't teach me constitution. That is only for those properties which are wholly or partly owned by the state or supported by the state. This is my private property. Get out. Okay? I will not tell you get out. I'll give you tea, coffee, whatever you want. And we'll have a beautiful conversation and then I'll tell you bye-bye. But the point is, Article 15, Clause 1, it says the state shall not discriminate against any citizen only on the grounds of religion, race, caste, sex, place of birth. That means if the state wants to discriminate, it can discriminate on other grounds, not on these grounds. On other grounds, it can discriminate. And what about fellow citizens? You and me, can we discriminate against each other? We cannot discriminate against each other only on the grounds of religion, race, caste, sex, place of birth. When? When you are trying to access public property, when you are trying to access public entertainment parks, when you are trying to access shops, when you are trying to access restaurants, which means I can still discriminate. But not only on the grounds of religion, race, caste, sex, place of birth. I have stopped you from coming to my shop. I will not give you medicine. I will not give you grocery. I'll not give you anything. And you can't even have an app. Blink it. Just blink your eyes and food will be delivered, grocery will be delivered. So you can't access my shop. You go to the court. Have you discriminated against him? Yes. How can you discriminate? He's saying you have discriminated only on the grounds of religion, race, caste, sex, place of birth. Said, my lord, he's suffering from COVID-19. The judge also disappears. So why are you approaching me? COVID-19, pandemic, gone. That means on medical grounds, I can discriminate. Somebody is suffering from leprosy. That is why there are separate colonies for those who are leprosy patients. Yes, the state is discriminating, but not only on the grounds of religion, race, caste, sex, place of birth, but because of medical condition. Somebody is discriminating against you on other grounds, but not only on the grounds of religion, race, caste, sex, place of birth. That is Article 15, Clause 2. Any questions? Yes, no, maybe. Okay. Now, when we say the state shall not discriminate only on the grounds of religion, race, caste, sex, place of birth, even this fundamental right is not absolute. There are some exceptions. Exceptions such as, nothing in this article shall prevent the state from making any special provision for the women and children. What does that mean? Section 497 of Indian Penal Code, which deals with adultery. What is adultery? If there is a husband and then there is wife, now comes an outsider. If this outsider indulges in sexual interaction with the wife, then this outsider has committed adultery, which is a crime for which 5 years punishment can be given to this outsider. What will happen to this woman? No action. Nothing will happen to the woman. But if this outsider is indulging in sexual interaction with the wife, but this time with the consent of the husband, with the permission of the husband, then this is not adultery. Why? Because this section 497 of Indian Penal Code said, basically affirmed, that wife is the property of the husband. So if this outsider is snatching the property of the husband, which is the wife, this is the classic case of theft. But if the husband is allowing this outsider to have sexual interaction with his wife, it is not theft because husband is in agreement. But no action will be taken against the wife. In Joseph Shine judgment, (2018), this section 497 was declared unconstitutional. Why? Because it violates the dignity of the woman. Because it treats women as a property of the husband, which violates their dignity. As such, this is unconstitutional. But why was the woman previously not punished for adultery? Because at that time there was this notion that man is always a seducer, woman is always a victim. So it is this outsider man who has seduced this woman. The woman is a victim, always a victim. Man is always the seducer. Matter went to the court. In 1954, in Yusuf Abdulaziz case, matter went to the court in 1988 as well. In Revati case, the principal question before the court was, why should women not be punished for committing adultery? And in both these judgments, the Supreme Court said, no, women should not be prosecuted, women should not be punished, because under Article 15, Clause 3, the state can make special provision for women and children. Because the petitioners in these cases, they argued that, my lord, Article 15 says, state shall not discriminate against its citizens only on the grounds of sex. But here is section 497 of IPC, which is a pre-constitutional law. A pre-constitutional law has to be in agreement with the fundamental rights. Section 497 is not in agreement with fundamental rights. Court asked how? Because this section 497 is discriminating against citizens only on the grounds of sex. Otherwise, there is no other reason. Only on the grounds of sex, women cannot be arrested for adultery, cannot be prosecuted for committing adultery. Only the outsider man can be prosecuted. So you are discriminating against citizens only on the grounds of sex. The court in both these cases said, no, it is not violation of Article 15 because Article 15 is not an absolute fundamental right. It comes under exceptions. What are these exceptions? Article 15, Clause 3. The state can make special provision for women as well as children. That is why if there is a demand that there should be seats reserved for women in parliament, just because of the sex, can the state discriminate? Yes. Why? Because for women and children, not for man. You can't say now 60% of the seats will be reserved for men in Lok Sabha. Although parliamentarians will pass this law, but this law will not sustain the test of judicial scrutiny because this law would be unconstitutional. You can make special provisions only for women and children, not for man. That's Article 15, Clause 3. Any questions as of now? Pre-constitutional law means the law which was in force prior to the commencement of the Constitution. Indian Penal Code was enacted in 1860. When was Constitution enacted? 1950. So Indian Penal Code is a pre-constitutional law. We've discussed that yesterday. Section 497 is now unconstitutional. It is not constitutional. Nobody can be arrested for adultery. But why we are discussing this case is because recently the Ministry of Defense had approached the judiciary. Why? My lord, there is Section 45 of Army Act. There is Section 63 of Army Act. There we punish male army officers as well as female army officers for adultery. That means these members of the armed forces, Army, Air Force, Navy, they are working and safeguarding the territory of India, and they are staying away from their family. Now, if somebody indulges in sexual interaction with them, whether it is a male or a female, we punish them for adultery and we even dismiss them from the service. But my lord, in 2018, you have decriminalized adultery. You are saying adultery is no longer a crime. Section 497 is unconstitutional. Please tell us whether we can punish people in armed forces, and please give us the permission to punish those members of the armed forces who commit adultery. The Supreme Court has now clarified that this 2018 judgment, this Joseph Schein judgment, it is available only for the citizens. The members of the armed forces can still be tried and committed and convicted for adultery, but not the members of the civilian public. But it will be applicable only for armed forces. Ripan, what's your question, please? Sir, this is not harm SC, ST, OBC or financially more capable than general, but they enjoy special privilege. We will discuss that in Article 16. So in Article 16, all your questions will be answered, where we will explain the whole concept of reservation. We have not discussed reservation yet. We will discuss the entire concept of reservation in Article 16. Can police arrest women for any criminal action? Yes. Why not? So if wife set an affair, it's not a crime. It's not a crime. Sir, on what grounds Section 497 declared void if it is not Article 15 violation? It's violation of Article 21, which talks about right to life and personal liberty, which also means right to dignity. If you are treating a woman as the property of the husband, it violates their dignity. That is why it is unconstitutional. Now, something else happened. What happened? Madras government immediately after the commencement of the Constitution in 1950 issued an order that what we want to do, we want to reserve seats in government engineering and medical colleges for those who belong to SC and ST community. Madras government issued an order and said we will reserve seats in government engineering and medical colleges for those who belong to SC and ST community. That means specifically on the grounds of caste, the state is discriminating, which is violating Article 15. Matter went to the court. Champak Dorai Rajan versus State of Madras, 1951. My lord, Madras government has issued an order which violates my fundamental right. I am Champak Dorerajan. Which fundamental right has been violated? How fundamental right has been violated? My lord, Article 15, Clause 1, which says the state shall not discriminate against any citizen only on the grounds of caste. How has the Madras government violated Article 15, Clause 1? Because only on the grounds of caste to the members of the SC and ST community, the Madras government is reserving seats in government engineering and medical colleges. The Supreme Court said this Madras government order is unconstitutional. Since you are providing reservation, which means you are discriminating only on the grounds of caste, which is not possible under Article 15, Clause 1. As such, this Madras government order is unconstitutional. When it was declared unconstitutional, that means there can be no reservation in educational institutions, only on the grounds of caste. But then Parliament got together and Parliament decides to amend the Constitution. And now Constitution was amended. Constitution was amended when a law was passed under Article 368. And that is what we call First Constitutional Amendment Act 1951. And this First Constitutional Amendment Act 1951 introduced Article 15 Clause 4 in the Constitution. And Article 15 Clause 4 basically adds another exception. What is the exception? If under Article 15, 1 and 2, there can be no discrimination only on the grounds of religion, race, caste, sex, place of birth, but Article 15, Clause 3 makes an exception that there can be special provision for women and children. Article 15, Clause 4 makes another exception that Article 15 does not bar the state, does not prohibit the state, does not make any limitation on the state from making any special provision. And this any special provision can be anything, can be reservation, can be scholarship. Article 15 does not bar the state from making any special provision for the advancement of those who are socially and educationally backward classes of citizens or SCs and STs. That means Article 15 Clause 4 imposed another exception that yes, the state cannot discriminate only on the grounds of religion, race, caste, sex, place of birth, but the state can. What the state can do? It can make a special provision. What is that special provision? Scholarships. What is that special provision? Reservation. What is that special provision? Free coaching for those who are socially and educationally backward, or those who belong to SC and ST community. And it is because of this Article 15 Clause 4, then the reservation was made possible in educational institutions, in government engineering medical colleges, in government educational institutions for all those who are socially and educationally backward, and those who belong to SC and ST community. What is the social and educational backwardness? Look at our society. Look at our history. Throughout our history, members of the Dalit community, SCs and ST community, they were discriminated against. They were discriminated, and we have discussed various forms of discrimination. When they were discriminated, that means they were not even allowed to apply for schools, get education. That means because they were socially discriminated, they also became educationally disempowered because they were not able to seek educational opportunities. So now this group became socially backward as well as educationally backward. Now for them, we need affirmative action. For them, we need distributive justice. For them, we need to fairly distribute the resources that are available in the state. And for them, we will provide them special provision. Maybe scholarships, maybe free coaching, maybe reservation. And this reservation became possible under Article 15(4) of the Constitution. Now you may have a question. Sir, how is it possible? Sir, what? Sir, how can you amend the Constitution and abridge a fundamental right, modify a fundamental right? And I've told you that as well. You cannot modify a fundamental right through an ordinary law. But you can modify a fundamental right only through a Constitutional Amendment Act under Article 368 of the Constitution. And using Article 368, Constitution was amended for the first time in 1951 when Article 15, Clause 4 was added to the Constitution. Clear? But then over a period of time, this reservation was provided only for the members of SC and ST community. Then came OBCs, other backward classes. And these other backward classes, they were also provided reservation. How OBCs were provided reservation, I'll discuss that in Article 16. But here, just keep in mind that OBCs were also provided reservation. Other backward classes were provided reservation in educational institutions. But originally, this reservation was provided only in government schools, government colleges, government educational institutions. Now the demand was that we need this reservation not only in government, but also in private institutions. And in private institutions, private institution can be either aided or unaided. What does that mean? Here is a private educational institution, but this private educational institution gets aid from the government, state, gets funding from the government, state. Or there is a private educational institution which does not get any aid from the government, which does not get any funding from the government. We call it unaided educational institution. So this private institution, private educational institution, can be aided or can be unaided. Then we have another kind of institution known as minority educational institution. These minority educational institutions are protected under Article 30 of the Constitution. For example, which are these minorities? Muslims, Christians, Buddhists, Jains, Parsis, Sikhs. These are the 6 religious minorities. These are the 6 minorities. If these minorities establish educational institutions, we call them minority educational institutions. Clear? Now the demand was that if we are providing reservation in only government educational institutions, we need to extend this reservation to private sector as well. We need to expand this reservation to private sector as well. And for that, another time, Constitution was amended. Because previously you could have provided only for government institutions. Now you have to specifically mention that we are providing it for private institutions as well. That is how 93rd Constitutional Amendment Act was passed in the year 2005. UPA government was in power and Article 15 Clause 5 was added to the Constitution. And it is this Article 15 Clause 5 which says, now for these backward classes of citizens, for those who are socially and educationally backward, for those who belong to SC and ST community, for those who belong to the OBC category, all of them will be provided reservation in educational institutions. But this educational institution can be government, can be a private as well, can be private aided institution or private unaided institution. The only type of institution, the only category and kind of educational institution which is kept out of the reservation system, these are minority institutions. In minority educational institutions, there will be no caste-based reservation. There will be no reservation for SCs, STs, OBCs. but there will be reservation in all educational institutions, whether government or private, whether aided private or unaided private, for all those who are socially and educationally backward, including SCs, including STs, and 2 years later, in 2007, OBCs were also provided reservation. Which means, as of now, we have close to 15% reservation for SCs. We have close to 7.5% reservation for STs, and we have 27% reservation for OBCs, which means close to 49.5% reservation on the grounds of social and educational backwardness. But when it comes to purely research-based institutes, such as TIFR, Tata Institute for Fundamental Research, there will be no reservation for OBCs. But be that as it may, something else happened in 2019. 103rd Constitutional Amendment Act was passed, and now seats were reserved. Up to 10% seats were reserved for those who belong to economically weaker sections of the society. That is Article 15 of the Constitution. So what is Article 15? Let's summarize. Article 15, Clause 1. You don't have to remember clauses. Just understand the concept. I'll still go clause by clause so that there is continuity, there is clarity. Article 15, Clause 1 says, the state shall not discriminate against any citizen only on the grounds of religion, race, caste, sex, place of birth. That means, can the state discriminate? Yes. But on what grounds? Grounds other than religion, race, caste, sex, place of birth. Not just the state, fellow citizens also cannot discriminate against their fellow citizens only on the grounds of religion, race, caste, sex, place of birth. When these citizens try to access public property, try to access shops, try to access means of entertainment, try to access public wells, public ghats, burial grounds, cremation grounds. But if there is no discrimination only on the grounds of religion, race, caste, sex, place of birth, this fundamental right is not absolute, because there are exceptions. Exceptions are for women and children, special provisions can be made. Exceptions are for those who are socially and educationally backward, special provisions can be made. That means those who are from SC and ST community, they will be provided reservation. Then this reservation was initially provided for government institutions. Now this reservation was to be extended to private institutions as well. So reservation got extended to private institutions as well, whether aided or unaided. The only kind of institution which is kept out of the reservation system, caste-based reservation, are the minority educational institutions. That is why, if you look at Lingayats of Karnataka, they have been for a long time demanding minority status. They're saying, we are not Hindus. You give us the separate religion status, and you also give us the minority status. Why? One principal objective of why there is a demand from various sections asking for a minority status is that we will be able to establish educational institutions for our own community. And in these educational institutions, minority educational institutions, there is no reservation for SCs, STs, OBCs. And then in 2019, apart from social and educational backwardness, another criteria was introduced in the Constitution. And the criteria was economically weaker sections of the society. Now, if 15% seats are reserved for SCs, 7.5% are reserved for STs, 27% are reserved for OBCs, not more than 10% shall be reserved for those who are from economically weaker sections of the society. Whether this is good or bad, we will discuss this after the break, when we will talk about Article 16 of the Constitution. Any questions as of now? No. Amrit, what's your doubt, please? What is the person can sue or be sued? If you have committed any crime, I can file a case against you. If I have violated your dignity, you can file a case against me. If I have snatched your property, you can file a case against me. If I have snatched your property, you can file a case against me. Which means the right to knock the doors of the court are open for all. Anybody can approach the court. The doors of the court are not open only for the rich, affluent sections of the society. The doors are open for anybody. Clear? Sir, how they amended in 2005, 2019, there is already judiciary intervened with doctrine of basic structure. That is why I said basic structure does not mean you cannot amend the constitution. Basic structure means you cannot amend the basic structure of the constitution. Those fundamental rights which are not part of the basic structure can be amended. Without disturbing basic structure, you can amend the constitution. And these amendments did not disturb basic structure. That's what the court said later. Even the recent EWS reservation judgment, which we will discuss today, the court said there is no violation of basic structure. So it was allowed. Amrit, or just Pakistanis, but what is your question? Persona non grata. Persona non grata is applicable to those who come under Vienna Convention. Yes, it's not only applicable for Pakistanis. Any diplomat who has violated the law in this country, and we don't want that diplomat to stay in India, we can declare them as persona non grata. We will give them a time period, and within that time period, they have to leave this country. Article 15, Clause 4 provided reservation for those who are socially and educationally backward, which means SCs and STs. Clear? But only in government institutions. Then 15 Clause 4 was added to provide reservation for those who are socially and educationally backward in all institutions, whether government or private, whether aided or unaided, except the minority educational institutions. Then in 2007, the government, by passing a law known as Central Educational Institutes Reservation of Seats Act, they said even OBCs are socially and educationally backward. And OBCs should be given reservation in government institutions, in private institutions, whether aided or unaided, except the minority institutions. And then in 2019, Article 15, Clause 6 provided reservation to economically weaker sections of the society. Mantaj, what's your question, please? We'll discuss Article 16 when we meet at 7:45 a.m. See you on the other side of the break. Now let's get started and look at Article 16 of the Constitution. And in Article 16 also, we have to discuss various clauses, 1, 2, 3, and so on. But you don't have to memorize clause by clause, just understand the concept. Article 16, Clause 1 says, there shall be equality of opportunity for all the citizens relating to the employment or appointment to any office under the state. Which means every single citizen of this country, which means this fundamental right is also not available to aliens. It's exclusively available to the citizens of India. All the citizens of India, whenever the state, and you know the definition of the state under Article 12, whenever the state is announcing jobs, advertising posts, and in all these appointments, there should be equality of opportunity to all the citizens to get these jobs. To make it even clear, Article 16, Clause 2 says, no citizen shall, only on the grounds of religion, race, caste, sex, place of birth, but two more grounds have been added now, descent, residence, or any of them, be ineligible for or discriminated against in respect of any employment or office under the state. What does that mean? No citizen can be discriminated or can be made ineligible. So you are from a particular religion, race, caste, sex, place of birth, residence, or descent, whether you are a citizen of India by birth or you are a citizen of India by descent, no matter what you are, on these grounds, you cannot be made ineligible to apply for government jobs. Just because you are from these particular grounds, religion, race, caste, sex, place of birth, descent, residence, you cannot be ineligible to apply for a job, or you cannot be discriminated against. On these grounds, there can be no discrimination whatsoever. Which means if at all there has to be discrimination, if at all the state has to discriminate, there must exist an 8th ground, 9th ground, 10th ground, or nth ground on the basis of which the state can make valid discrimination. What does that mean? You applied for the civil services examination and you want to become an IAS or an IPS or an IFS or an IRS officer, which is an employment or an office under the state. The state is the government of India, or State Public Service Commission, or Indian Engineering Service, Statistics Service, any exam. If you want to apply for these government jobs, the state cannot discriminate against you, or the state cannot make you ineligible. Because you are from a particular religion, you are ineligible for this job. That cannot happen. Because you are from a particular caste and we will discriminate, we will ensure that you are not selected for this job. That cannot happen. Only on these grounds there can be no discrimination. That means if at all the state has to make discriminate against its citizens, it can be on grounds other than religion, race, caste, sex, place of birth, residence, descent, or any of them. Which means if you're applying for the civil services exam, you want to become an IAS officer, but UPSC is not selecting you, UPSC is not recruiting you, then you can drag UPSC to the court. My lord, my fundamental right has been violated. Which fundamental right? Article 16. It says I cannot be discriminated, I cannot be made ineligible because of these reasons. And it is because of these reasons UPSC has not selected me. UPSC, which is a state under Article 12, will be called to question, how can you discriminate against the citizens on these grounds? UPSC will say, yes, we have discriminated, but we have discriminated on other grounds. Grounds such as age. This particular gentleman who has filed a case, his age is 33. But we have made it clear in the notification itself that the age is 21 to 32 if you belong to the general category. This person belongs to the general category. That means he is not ineligible. He is not eligible, not because of his religion, race, caste, sex, descent, place of birth, residence, but ineligible because of age, ineligible because of merit, ineligible because of medical grounds. Medical grounds, for example, if you want to become an IPS officer, for that you should not be suffering from flat foot. So look at the feet that you have. There is some curve. If it is flat, you are ineligible for IPS. That means you can't say I have been discriminated against only on the grounds of religion, race, caste, sex, place of birth, descent, residence, but you have been discriminated on medical grounds. You may be discriminated on other grounds. For example, there is a report by Intelligence Bureau. There is a report by intelligence agencies that you are basically the enemy of India. You have basically indulged in violence. You have indulged in terrorism, for which you were convicted by the court previously as well. Now you are not eligible to get this government job because of your other grounds, not only on the grounds of religion, race, caste, sex, place of birth, or residence or descent. But then, sir, what is happening in the different states? What is happening? Sir, there are various states, when they advertise jobs under the State Public Service Commission, for example, Karnataka, for example, Madhya Pradesh, for example, various states in India, they reserve some of these jobs for their own people, for their own residents. For those who are residing in Karnataka, seats are reserved, jobs are reserved for them. Is it not discrimination on the grounds of residence? No. Why? Because the seats are reserved not on the grounds of residence, but on the grounds of domicile. And we have discussed in the previous class, when we discussed citizenship, what is the difference between the residence and domicile? Residence mean I am from Delhi, I'm staying in Karnataka, I'm residing in Karnataka. Just because I'm residing in Karnataka, that does not mean I become the domicile of Karnataka. I have to reside in Karnataka for an indefinite period, let's say 15 years, so that my intention is to reside in Karnataka for an indefinite period. Then I become the domicile of Karnataka. And then for the domiciles of Karnataka, seats can be reserved in government jobs. Long story short, Article 16 talks about equality of opportunity when it comes to public employment. That means when the government advertises posts, invites applications for government jobs, there should be equal opportunity to all the citizens of India to get this government job. And Constitution says no citizen shall be discriminated only on the grounds of religion, race, caste, sex, place of birth, descent, or residence. On these grounds, there can be no discrimination. Which means if the state has to discriminate, there must exist other grounds other than those mentioned under Article 16. Which means on age there can be discrimination, on merit there can be discrimination, on medical grounds there can be discrimination, on other grounds there can be discrimination, but not only on the grounds of religion, race, caste, sex, place of birth, descent, or residence. Is that clear? Now, just like other fundamental rights, which we have discussed till now, 14, 15, this fundamental right, Article 16, also is not absolute. Absolute in the sense, there are exceptions. What are exceptions? Exceptions such as Article 371 capital J. For example, what is Article 371 capital J? It was introduced into the Constitution by 98th Constitutional Amendment Act. That means it was amended to the Constitution, added to the Constitution by the 98th Constitutional Amendment Act. What this Article 371 capital J talks about? That there are 6 backward districts where in Hyderabad, Karnataka region, Which are these 6 backward districts? You don't have to remember, but very briefly here. For example, Bidar, Gulbarga, Raichur, Bellary. There are 6 backward districts in Hyderabad, Karnataka region. Clear? And if you want to apply for a government job, if you want to apply for a state job, that means the job which is announced by the state government of Karnataka, or for that matter, State Public Service Commission of Karnataka, you should be the resident of these 6 backward districts. Only the residents of these 6 backward districts will get government jobs at the state level in these 6 backward districts of Hyderabad, Karnataka region. Which means, what is Parliament doing? Parliament is pronouncing residence as a qualification for a government job. In Article 16, we say there can be no discrimination only on the grounds of residence. But this fundamental right is not absolute. There is an exception. The exception is Parliament may, by law. What Parliament can do? It can pass a law. What is the law? 98th Constitutional Amendment Act. What it inserted into the Constitution? Article 371 capital J. Through this article, what happened? Residence was made a qualification for a job. That means if there are 6 backward districts of Hyderabad, Karnataka region, if you want to apply for a government job in these areas, in these 6 districts, you should be the resident of these 6 districts. That means residence is the qualification for this job. And you need to understand 2 things. One, this power is given only to the Parliament, center, not to the states. Otherwise, all states will say, we will pass a law, only those who are the residents of Karnataka, they will get jobs in Karnataka. Only those who are the residents of Bihar, they will get jobs in Bihar. Then how can we implement the beautiful objective of the Constitution, which is mentioned in the preamble, known as fraternity? That means we are then creating different countries within this big country called India. That means we will not allow people from other states to get jobs in your state. That violates the principle of fraternity. That is why this power is given only to the Parliament, not to the state legislature. And this reservation, in a sense, this residence as a qualification to become an officer, to get a government job, is only at the state level, not with regards to the union appointments, which basically means that Article 371 capital J provides residence as a qualification. If you want to get a government job in the 6 backward districts of Hyderabad, Karnataka region, that doesn't mean that those who are the residents of Hyderabad, Karnataka region, they will get reservation in union level jobs, in UPSC. That does not happen. And that is Article 16, Clause 3, which means Parliament may, by law, what Parliament can do, it can prescribe residence as a qualification for certain jobs in a state, not at the central level, but only at the state level. For example, we used to have mulki rules in Telangana, in Hyderabad, for example. Mulki rules, if you were born in Hyderabad and if you were staying in Hyderabad for 15 years, only you are eligible for various government jobs in Hyderabad. These mulki rules were not unconstitutional. Why? Because they were conferred by the center. Although this order was issued by the Nizam, when Nizam was ruling Hyderabad, but it was extended after the constitution entered into force. It was extended for a period of 10 years. That is why today there is a demand from Telangana that we should have mulki rules back again. But it has not happened. But it used to happen for those who are born in Hyderabad, stayed in Hyderabad, resided in Hyderabad for 15 years, only they can apply for various jobs at the state level. Now, mulki rules are not present. Mulki rules have been discarded. But what is it that you need to understand is that Article 16, just like Article 14 and 15, is not absolute. Exception is there. And what is the exception? If there is no discrimination on the grounds of residence, but residence can be the qualification for certain state level jobs, and this qualification can be prescribed only by Parliament by passing a law. Clear? Any questions as of now? Good. Now something else. Article 16 clause 4. Similar to Article 15 clause 4. There was no provision of reservation for SCs and STs in educational institutions. Originally, in the original constitution, when it was enacted on 26 January 1950, there was no reservation for socially and educationally backward classes of citizens for SCs and STs in educational institutions. This reservation was provided through the Act of the Parliament. This reservation was provided when the Constitution was amended in 1951. But there was always reservation. Right from the time the Constitution was enacted, there was always reservation for those who are socially and educationally backward in public employment, for those belonging to SC and ST community. That means Article 16 clause 4, which was present in the original constitution when it was enacted on 26 January 1950, this Article 16 clause 4 basically provided another exception. What is the exception? If there can be equality of opportunity in public employment, if there can be no discrimination when it comes to the matters related to public employment, but there can be reservation. The state is empowered to reserve seats. For whom? For those who are backward. Who are these backward people? Members belonging to SC and ST community, if they are not adequately represented in the services. If their proportion if their representation is not adequate, if the number of SCs and STs in government jobs are less, way below their population, then the state can reserve seats for the members belonging to SC and ST community. And for that, 15% reservation was provided to SCs, 7.5% was provided to the members of the ST community. Clear? Let's now look at something else. 1975, emergency was imposed in India. Shrimati Indira Gandhi was the Prime Minister. When emergency was imposed, after that, 2 years later, there were elections in India, 1977, and the Congress party lost the election. And Janata Party came to power. Shri Morarji Desai became the Prime Minister of India. And the central government set up a commission known as, which was headed by a politician from Bihar, Mr. B.P. Mandal. And this commission is known as Mandal Commission. Mandal Commission was asked, can you please identify? Mandal Commission said, what? Those who are socially and educationally backward. Other than SCs and STs. Said what? SCs and STs, we know they belong to socially and educationally backward classes of citizens. Yes. And for them, we provide reservation in government jobs. Said yes. We also provide them reservation in educational institutions. Mandal Commission said, yes, we know that. Could you please identify others who are also socially and educationally backward, but they are not SCs and STs? Because SCs and STs we have identified, they are backward, we provide them reservation. But apart from SCs and STs, look at the entire population, and could you please identify those who are socially and educationally backward so that we can provide benefits to them? Mandal Commission said, no issues, we will identify. Mandal Commission came up with its report and said there is 52% of our population, other than SCs and STs, they are also socially and educationally backward. That means if we look at the population of India, apart from SCs and STs, when we look at the entire population, we can identify based on history, based on evidence, based on research, that there is 52% of our population which is also socially and educationally backward. And Mandal Commission said we will call them OBCs. What is OBC? Other backward classes, other than SCs and STs. And Mandal Commission said for these OBCs, 27% seats shall be reserved. There should be 27% reservation for OBCs, for other backward classes, in government jobs, in educational institutions as well. Janata Party lost power. Srimati Indira Gandhi came to power. She did not act on this report. She kept the report in a refrigerator, on a back burner. She did not implement this report. Indira Gandhi was assassinated. Her son, Rajiv Gandhi, became the prime minister. He also did not implement this report. And Rajiv Gandhi then got embroiled in a controversy known as the Bofors. There were guns, Bofors guns, which were imported by India, and it was argued that there is an element of corruption involved. Some kickbacks were given, some money was given, some bribe was given. Rajiv Gandhi is responsible. Rajiv Gandhi's the then best friend, Amitabh Bachchan, was also responsible. According to allegation, later on court said Amitabh Bachchan is not guilty. Amitabh Bachchan then was the member of the parliament from Allahabad constituency, and he then resigned. Rajiv Gandhi had a defense minister. His name was Vishwanath Pratap Singh. VP Singh. VP Singh was the defense minister when corruption allegations were raised in the Bofors case against Rajiv Gandhi, against some members of the government, against Amitabh Bachchan. VP Singh resigned. And he launched a movement against corruption. Just like Anna Hazare, Arvind Kejriwal launched a movement against corruption in 2011. In the similar fashion, VP Singh also launched a movement against corruption. And then in 1989, when elections were held, no political party got the majority. But VP Singh, who has now started a different political party, he got a good number of seats because he was viewed as a messiah of the people against corruption. And VP Singh was supported by two political opposites, BJP and the communists. Just like today, when all political parties are trying to come together against the BJP, because BJP is a formidable political force. At that time, it was Congress which was a formidable political force. Today, if opposition is trying to come together so that BJP does not come to power, in the similar fashion, opposition then, they work together so that Congress does not come to power. And this time, VP Singh was supported by the BJP, by the communists as well. You become the Prime Minister of India. And VP Singh became the Prime Minister. When VP Singh became the Prime Minister, he realized that I may not survive for long because I'm supported by two opposite political ideologies. BJP is a right-wing political party, communists are left-wing political party. He wanted to leave his legacy so that even after decades, people will talk about VP Singh, just like we are talking about VP Singh today. And what VP Singh did, he implemented the Mandal Commission recommendations. Implemented Mandal Commission recommendations and gave 27% reservation for OBCs in public employment, in government educational institutions. Then BJP was in a fix. Why? Because BJP then, if not today, BJP then was viewed as a political party belonging to the upper castes, belonging to the Brahmins or the Thakurs, the upper castes of the Hindu community. And who were the beneficiaries of the Mandal Commission? Yadavs, Kurmis, others who belonged to other sections of the society, weaker sections of the society. They were not upper castes or upper sections of the Hindu community. The BJP was in a fix. Either we should support Mandal, then we will lose our vote bank, which is the upper castes of the Hindu society, or we will go back to Mandir. What is mandir? We should construct a mega Ram temple at the disputed site at Ayodhya. And Lal Krishna Advani, he started a Rath Yatra from Odisha, and he wanted to create an awareness so that a mega Ram temple is constructed at the disputed site at Ayodhya. And the BJP withdrew support to the VP Singh government. VP Singh government fell. When VP Singh government fell, in came Congress again, but this time Rajiv Gandhi was unfortunately assassinated. PV Narasimha Rao became the Prime Minister. PV Narasimha Rao said, what should I do? 15% reservation for SCs, 7.5% reservation for STs. Now what has VP Singh done? 27% reservation for other backward classes, OBCs. I also want to make a mark. I also want to leave a legacy. I will provide 10% reservation to the poor, to economically weaker sections of the society. When this Mandal Commission report was implemented, when reservation was announced for OBCs, there were massive protests in different parts of the country. Violent protests at the Delhi University. In fact, there was a Delhi University student who later on became very popular, but after his death, unfortunately, who self-immolated himself, who burnt himself alive. His name was Goswami. Not the other Goswami, still alive, still screaming at the top of his voice every 9 o'clock because the nation wants to know. But be that as it may, massive protests in different parts of the country. And then there was one lady advocate, lady lawyer. Her name was Indra Sani. What Indra Sani did, she filed a petition before the court, challenging the constitutional validity of OBC reservation, challenging the constitutional validity of this 10% reservation for the economically weaker sections of the society, the poor sections of the society. And now the 9-judge bench of the Supreme Court had to decide whether this OBC reservation is constitutional or unconstitutional. Now let's look at what did Indra Sani versus Union of India 1992 case decide, and this case is also known as the Mandal case. Now listen to me carefully. There was no challenge to reservation in public employment for SCs and STs in this case, because it was already provided. There was no challenge to the reservation provided to SCs and STs in educational institutions, because that case was already decided in the 1950s. In 1992, the case was specific to, is OBC reservation constitutional? The case was specific to, is 10% reservation constitutional for poor? Why? Because Constitution makes it clear under Article 15, under Article 16 as well, that the state shall provide benefit for those who are socially and educationally backward. Economic backwardness is not a criteria mentioned in the Constitution. Constitution empowers the state to provide reservation or to provide benefit, which can be scholarship, which can be free coaching, which can be reservation, but for those who belong to socially and educationally backward classes of citizens, not economically backward classes of citizens. So whether this 10% reservation for economically poor, whether this 10% reservation is constitutional, and whether this OBC reservation is constitutional, these are the two critical points that Supreme Court had to decide in Indra Sani versus Union of India. And the Supreme Court said, number one, Article 16 Clause 4 is an enabling clause. Enable clause in the sense, it is Article 16 Clause 4 which enables reservation. But reservation is not a fundamental right. Sir, what are you saying? Reservation is not a fundamental right. Sir, how can you say this? Look at Article 15 of the Constitution. Article 15 Clause 4 does not bar the state, does not prohibit the state from making any special provision for the advancement of socially and educationally backward classes of citizens. Tell me, is there any mention of the word reservation in Article 15, Clause 4? No. Article 15, Clause 4 only talks about making a special provision. Special provision can be scholarship. Special provision can be free coaching. Special provision can be reservation as well. But Constitution does not say that you have the right to reserve seats for socially and educationally backward class of citizens. Sir, but Article 16, Clause 4 explicitly talks about reservation. How? It empowers the state to reserve seats in favor of backward class of citizens. Sir, Article 16 talks about reservation. So reservation is a fundamental right. Supreme Court said, no, read Article 16, Clause 4 in great detail. Read it fully. It says the state can reserve seats provided if these classes are not adequately represented in the administration. That means what we need data. What is the data? If you are providing OBCs 27% reservation, first you have to tell me on what grounds are you identifying that these are the castes who are socially and educationally backward. That means first there should be a commission. There should be a body which should do research, which should conduct a study to identify, and on what grounds are you identifying them as socially and educationally backward. And once you have identified them, show us what is their representation in administration. If OBCs are 52% of the population, but in the government jobs they are 70%, that means they are adequately represented in administration. That means there is no discrimination. So why should you provide reservation to them? But if you say that these are socially and educationally backward classes of groups, if this is the OBC list, tell us how have you identified these caste groups? On what grounds? On what parameters? On what basis? And once you have identified, if we are satisfied that yes, this is done logically, then give us the data. How many of these individuals are occupying government jobs, are occupying government positions? If they are adequately represented in the administration, then you can't reserve seats for them. Then you can't provide them reservation. That is why we are saying reservation is not a fundamental right. Reservation is at the discretion of the state. If the state wants to give reservation, it can. If the state does not want to give reservation, it may not. Right to reservation is not a fundamental right. Because Article 16, Clause 4, which enables reservation, it enables reservation for those who are socially backward, educationally backward, and at the same time, they are not adequately represented in the administration. And whenever you provide reservation, 5 constitutional requirements must be met. Without meeting these 5 requirements, you cannot provide reservation to any group, except SCs and STs, because that was not challenged in this case. What are these 5 requirements? Number 1, prove to us that they are socially and educationally backward. Show us your study. How have you studied these groups? On what parameters, on what basis are you saying that these are socially and educationally backward? So first, we need to be assured that this list of OBC, they are socially and educationally backward. Second, you have to prove to us that they are not adequately represented in the administration. Third, concept of creamy layer shall apply. What is this creamy layer? Here is an OBC. But there is one OBC and there is another OBC. What is one OBC? He belongs to this group, but his father is holding a constitutional post. Father is the president. Father is the governor. Father is the judge of the Supreme Court or High Court. Father is the CAG, holding a constitutional post. You belong to creamy layer, no reservation to you. If you are holding land which is more than 5 acres, you belong to creamy layer, no reservation for you. If your annual family income is 8 lakhs, initially it was 2.5 lakhs, then it was raised to 5 lakhs, then it was raised to 6 lakhs, now it is raised to 8 lakhs. And now if you belong to OBC, but your father is holding a constitutional post, or if you hold an agricultural land which is more than 5 acres, or if you own a property in a municipal area which is more than 1000 square feet, if your annual family income is 8 lakhs, then you belong to creamy layer, no reservation to you. That means reservation can be given to only those OBCs who belong to non-creamy layer. So the Supreme Court said, yes, OBC reservation is constitutional. You can provide reservation to the OBCs. But keep in mind, right to reservation is not a fundamental right. Reservation can be given at the discretion of the state. If the state wants to give reservation, it can. If the state does not, you cannot force the state to give reservation. And even if OBC reservation is constitutional, you will have to satisfy 5 constitutional requirements. Number 1, prove to us that they are socially and educationally backward. Prove to us that they are not adequately represented in the administration. Reservation will apply only to the non-creamy layer. Creamy layer will not get reservation benefit. And reservation cannot at any point exceed 50%. That means if there are 100 seats, 100 jobs advertised, 15 can be reserved for SCs, 7.5 can be reserved for STs, 27 can be reserved for OBCs. Maximum reservation can be 50. It cannot be more than 50. Except in unusual circumstances. Or compelling circumstances. That means you can breach this 50% cap. You can violate this 50% limit as well, but only in extraordinary circumstances, only in compelling circumstances, unusual circumstances. But otherwise, you will have to stick to 50% limit. And fifth, everything is possible subject to Article 335. And what is the subject to Article 335? Subject to the efficiency in administration. You can't say that we will provide reservation to OBCs, but then you will lower down the merit to such a level that these people will not be able to efficiently manage the work. If the educational requirement is graduation, you cannot say that for OBCs it should be 10th pass. You can tweak the percentage. You can say for graduation, your percentage, if for others it's 50%, for you it can be 40%. But you can't say you should not be a graduate, even then you will be eligible for this post, because then efficiency will be flirted with. Do whatever you want to do, provide reservation, but don't flirt with the efficiency in administration. That cannot happen. Efficiency in administration should not get affected, should be maintained at all costs. OBC reservation is constitutional. But Supreme Court was further asked, sir, what about 10% reservation given to the economically poor, weaker sections of the society? Supreme Court said this reservation, 10% reservation for economically poor, weaker sections of the society, this is unconstitutional. Why? Because Constitution recognizes only 2 kinds of backwardness, either social backwardness or educational backwardness. Economic backwardness is not a criteria at all. There can be no reservation on economic grounds, only for those who are socially and educationally backward. Supreme Court went a step further. Supreme Court said, again, reservation can only be at the level of the entry, only at the entry level, not at the time of promotions. That means once you're recruited, there can be reservation. But later on, when all those who are recruited, they are to be promoted. For example, 10 people are to be promoted. In these 10 people, we will not have reservation. Once you're recruited, you're recruited. On the basis of reservation, you are recruited, that means no discrimination. But after that, there shall be no reservation. There is no reservation in promotion. That is what Supreme Court said in Indira Sani versus Union of India, 1992 case. OBC reservation is constitutional, but subject to 5 requirements. But there can be no reservation in promotion, and there can be no reservation for economically weaker sections of the society, poor sections of the society. When the Supreme Court said that there can be no reservation in promotion, Parliament got together again. Parliament amended the Constitution again. Article 16(4) capital A was provided, inserted into the Constitution. 77th Constitutional Amendment Act was passed. The year was 1995, and it is this 77th Constitutional Amendment Act. It is this Article 16(4) capital A which provides reservation and promotion for those who are SCs and STs. So if the Supreme Court said there can be no reservation and promotion, reservation only at the time of the entry, reservation only at the time of the recruitment, there can be no reservation and promotion, Parliament said, so what? We will come together, we will amend the Constitution. 77th Constitutional Amendment Act was passed, and reservation and promotion was provided to the members of the SC and ST community. Not for OBCs, but only for SCs and STs, there is reservation and promotion. Matter went to the court again. My lord, I have a case. I said, what case? Sir, in 1992, you said there can be no reservation and promotion. I said, yes. Do you know what Parliament has done? What? Sir, they have amended the Constitution. Really? Yes, sir. 77th Amendment, 1995. They have inserted Article 16(4) capital A to the Constitution. Sir, please declare that unconstitutional. I said, okay, come to us. The government, what have you done? Sir, we have amended the Constitution. Why? Sir, Article 368 gives us the power to amend the Constitution. We have done that. But why? Sir, we want to provide social justice. Why? Sir, we want to provide reservation and promotion to SCs and STs. But why? Sir, there is discrimination against them. Sir, how are you saying this? Sir, even if they are recruited, but then they are not promoted to the higher level. So only those who are members of upper castes, they are promoted because they are being victimized. Whenever a member of the SC and ST community is recruited in government jobs on the basis of reservation, then the entire work culture is forced in such a manner that they are not allowed to grow, they are not promoted. So there is a discrimination against them when it comes to the matters related to promotion. So, okay, prove it. Sir, what are you saying? Prove it. Sir, what? Prove that they have been discriminated. Sir, what we have to do then? First, you have to prove us that SCs and STs are socially and educationally backward. But that is something that we proved in the last case, in Indira Sani case. That was for OBCs. SCs and STs were not challenged at that time. There was no challenge to SC-ST reservation. Indira Sani judgment was specifically to ask and answer whether OBC reservation is constitutional. You have to provide reservation to SCs and STs if they are socially and educationally backward. Prove that they are socially and educationally backward. Okay, sir, we will prove it. Second, prove to us that they are not adequately represented in public employment. Sir, what does that mean? You're saying that they are recruited, but there is discrimination, they are not promoted. Show us that data. That of all these people who are recruited on the basis of reservation, what is the percentage of them who are not being promoted? If we can see that, yes, there is a definite, deliberate discrimination against them when it comes to matters related to promotion, we have no problem, but give us the data. Said, okay, sir, I will come up with the data. Well, listen, but don't flirt with the efficiency in administration. Do not randomly promote members of the SC and ST community. You don't have to promote them, and if it affects efficiency in administration, we will not allow. So promote in a decent manner, not randomly, because you have to ensure efficiency in administration. Give us these 3 documents and we will give a go ahead to reservation and promotion. And then the government provided, whenever reservation and promotion is to be provided for SCs and STs, They have to explain that they are socially and educationally backward. They're not adequately represented when it comes to promotion, and we will not violate the efficiency in administration. And now there is reservation and promotion also for the members of SC and ST community. There is no reservation and promotion for OBCs. There is reservation and promotion for SCs and STs. So what have we discussed as of now? Article 16 talks about equality of opportunity in public employment, which means the state shall not discriminate against its citizens only on the grounds of religion, race, caste, sex, place of birth, descent, residence. On these grounds alone, there can be no discrimination. Which means if the state has to discriminate, there must exist other grounds other than these grounds. But then just like other fundamental rights, this fundamental right also is not absolute. That means there are some exceptions. What are the exceptions? If there is no reservation, if there is no discrimination on the grounds of residence can be a qualification for certain state posts. But who can impose this residence as a qualification? Parliament, not the state legislature. Similarly, if there is no discrimination only on the grounds of caste, but there can be discrimination for those who are socially and educationally backward. And that is how we have provided reservation in public employment to SCs and STs, then provided reservation in public employment to OBCs, then provided reservation in promotion to the members of the SC and ST community. But there is no reservation and promotion for OBCs. Then something else happened. Jarnail Singh versus Lakshmi Narayan Gupta, 2018. This judgment, which was authored by Justice Rohinton Fali Nariman, this judgment said, okay, there is reservation and promotion for SCs and STs, but there we will have to implement creamy layer. When it comes to OBCs, all OBCs are not given reservation. Only those who belong to non-creamy layer, they get reservation benefit. But when it comes to reservation for SCs and STs, there is no such thing as creamy layer. There is no such thing as non-creamy layer. All SCs and STs, they get reservation regardless of their economic criteria. But then in 2018, Supreme Court said, when it comes to promotion, not at the time of the entry, not at the time of the recruitment, at the time of the recruitment at the entry level, all SCs and STs will get reservation. But only those will get reservation and promotion, those who belong to non-creamy layer amongst SCs and STs. So in SCs and STs, you also have creamy layer, non-creamy layer. And those who are from non-creamy layer, only they will get the reservation benefit in promotion, not the members of the creamy layer. That is the current status. That means in promotion, only the non-creamy layer SCs and STs get the promotion, not the members of the creamy layer SCs and STs. Something else happened. Mukesh Kumar versus State of Uttarakhand, 2020. Uttarakhand government issued a notification, a recruitment notification. Don't ask me any questions as of now. Just listen to me patiently. Once Article 16 is over, I am sure you will have no doubts. Even if there are doubts, we will discuss them later. Right now, sit back, relax. Don't ask any questions. Don't waste your time. Uttarakhand government issued a notification inviting applications for government jobs. And this notification said no reservation in promotion for SCs and STs. Uttarakhand government issued a notification inviting application for government jobs, and in this notification it mentioned that there shall be no reservation and promotion for SCs and STs. Matter went to the Uttarakhand High Court. Uttarakhand High Court said, how can you do this? reservation and promotion. How can you not provide reservation for SCs and STs? Uttarakhand government said, it's our discretion. We want to provide, we may not want to provide, and we have decided not to provide reservation and promotion for SCs and STs. Uttarakhand High Court said, no, you can't do that. So tell us then, what do we do? Give us the data. Said, all the time you're asking for data? Said, yes. On that data, we will make a judgment. Give us the data that SCs and STs are adequately represented in administration. That is why you don't need to give them reservation and promotion. Give us the data which can convince us that in higher positions of the government, there is adequate representation of SCs and STs, which means you don't need to provide them reservation and promotion. Give us this data. Uttarakhand government appealed before the Supreme Court. In the case Mukesh Kumar versus State of Uttarakhand 2020, Supreme Court said High Court is wrong. High Court should not have asked for data. Why? Because reservation is not a fundamental right. When reservation is not a fundamental right, that means reservation is at the discretion of the state. If the state wants to give reservation, it can. If the state does not want to give reservation, you cannot force the state to give reservation. So when the reservation is not a fundamental right, why are you seeking details from the state? They have decided that we will not provide reservation and promotion for SCs and STs. You can't force them. Which means in Mukesh Kumar case, Supreme Court has reiterated the same thing that was said by the Supreme Court in Indra Sani case. Reservation is at the discretion of the state. Reservation is not a fundamental right. Something else happened. Marathas were given reservation. Marathas in Maharashtra. Marathas are closer to 32% of the population in Maharashtra. And they are politically well off, in the sense they have political representation in large numbers. They have been chief ministers. They are also well adequately represented in administration as well. But whether because of political consideration or genuine, we don't know. But the government in Maharashtra said we will provide reservation to the Marathas in government, in educational institutions, as well as in government jobs. But for that, a commission was set up known as Maharashtra State Socially and Educationally Backward Class Commission, which was created under this act passed by the Maharashtra legislature. Because what has Supreme Court said in Indra Sani case? You can provide reservation to OBCs. Marathas are to be included in OBCs. Marathas are the OBCs, to be included in OBCs as the reservation criteria. Supreme Court in Indra Sani case said, you can include people in OBC group, but for that you have to tell us on what grounds have you included them. You have to prove to us that they are socially and educationally backward. Did you conduct a survey? Did you organize a commission? Was a study conducted? Through what means did you come to know that Marathas are also socially and educationally backward? That was what Supreme Court will ask if this is challenged before the court. That is why Maharashtra government passed a law, and through this law, it created a commission known as Maharashtra State Backward Class Commission. Mr. Commission, yes, come here. So what? Do a survey. And through this survey, prove to us that Marathas are socially and educationally backward. Because on the basis of your recommendation, we will then give reservation to Marathas in government jobs, in educational institutions. Go conduct this study, conduct this survey, and give us this data. And this commission said, we will provide 16% reservation to Marathas in education, and we will provide 13% reservation in jobs. Matter went to the Maharashtra High Court. Maharashtra High Court said, okay, Maratha reservation is constitutional, but we will reduce the percentage. We will reduce this percentage. Instead of 16, we will give 12% in education. We will give 13% in jobs. And that is how Marathas were made socially and educationally backward, and they were provided reservation. This reservation was challenged in the Supreme Court. And Supreme Court said this Maratha reservation is unconstitutional. Why? Because the first thing that you have to prove is whether they are socially and educationally backward. Various arguments were given by Maharashtra government that basis this commission which we have set up, they have recommended, they have identified that Marathas are socially and educationally backward. One grounds on the basis of which Maharashtra government said Marathas are socially and educationally backward, they said that some of them are dabbawalas. Their working was beautifully captured by this movie called Lunchbox, starring the late Irfan Khan. Beautifully was captured how dabbawalas play an important role in the Maharashtra society. But be that as it may, the state government said Marathas, a large portion of them, they are dabbawalas, which means they are socially backward, educationally backward, otherwise they would not do this menial job. That is why we have to provide them reservation. Supreme Court said, do you even understand what you're saying? I said, what? Do you know what is untouchability? I said, what is untouchability? Members of the Dalit community, they are not even allowed to give food to the members of the upper castes. They're not allowed to drink water, fetch water from a well which is meant for the upper caste. That means this discrimination that we have in the society is on the basis of the concept of purity and pollution. Your food is impure. Your drinking habits are impure. You're all impure. So if these dabbawalas, listen to me carefully, if these dabbawalas are preparing food and sending and selling this food and people are accepting this food, that means they are not socially backward. Because if they were socially backward, then their food would not have been consumed by others. Sir, they're not preparing food on their own. The food is prepared by the family members. They just courier this dabba to their relatives. That's all. Sir, even then it is not untouchability. Even then it is not socially backward. Why? Because even if the Dalit has not cooked the food, but he has touched the food, this food becomes polluting for the members of the upper caste. They won't touch this food, leave alone eat it. That is why Supreme Court said Marathas, they are not socially and educationally backward. When they are not socially and educationally backward, that means they will not be provided reservation. Which means in order to include any caste group in the OBC, 5 constitutional requirements are to be met. Those 5 constitutional requirements which are listed down by the Supreme Court in Indra Sani judgment of 1992. Is that clear? Any question as of now? Okay. Then something else. Supreme Court said if there are 100 seats or 100 jobs, for example, 50 are for open category, 50 under the reserved category. Open category, that means open for all. In open category, you can have people from general category, you can have people from SC, ST, OBC, any group. But these 50 will only be from the reserved category, only SCs, STs, OBCs, so on and so forth. The court said, if there are 100 seats and 50 had been reserved, what if only 30 have been filled? 20 are vacant. What will happen to these 20 seats? Will these 20 jobs be merged in the open category? Or will these 20 jobs will be carry forwarded to the next year? The government has said we will never recruit people from the general category under those seats which are reserved for the reserved category. We will carry forward these seats to next year, then to the next year, then to the next year. That means under no circumstance will we appoint people from the general category, open category in the reserved category. Supreme Court said no. Then in that way you are violating the efficiency in administration. Said yes. Then what you should do, if there are these 20 seats which remain vacant, carry forward them to the next year and fill them from the reserved category next year. If next year also they remain vacant, carry forward to another year. If next year also they remain vacant, carry forward them to another year. But maximum number of times you can carry forward these seats is 3 years. If in 3 years these seats are remained unfilled, you're not able to fill these seats from the members of the reserved category, then these seats will go under the open category. There was a lot of hue and cry at that time. It was alleged that the government will keep some seats unfilled, which are reserved for the categories. And after 3 years, it will merge these seats with the open category. It will be violating the rights of SCs, STs, and OBCs. Parliament said, don't worry, let's come together, let's amend the Constitution. Constitution was amended. 85th Constitutional Amendment Act was passed. The year was 2000. Mr. Vajpayee was the Prime Minister. Article 16(4) capital B was added. Under Article 16(4) capital B, these seats which remain vacant can be carry forwarded to the next year, then to the next year, then to the next year for n number of years. Under no circumstances, no matter what, these seats will never be merged with the open category. That is what we call carry forward policy. So what is carry forward policy? If there are seats which are reserved for certain categories and these seats remain unfilled, what will happen to these seats? Court said these seats will be filled by the open category after 3 years. Constitution was amended. Article 16(4) capital B was inserted into the Constitution. The year was 2000, 81st Constitutional Amendment Act. The Parliament said these seats under no circumstances will be merged with the open category. These seats will remain under the reserved category for n number of years. That is 16(4) capital B. Okay. Something else. Let's say, for example, there is a temple in Tirupati, TTD, Tirumala Tirupati Devasthanam. Now we have to appoint an officer to this TTD because there are temples which come under state, which are controlled by the state. Now we have to appoint an officer to this temple. Can we appoint a Muslim to this temple or a Christian to this temple? This will affect the sensibilities of the religious communities. But can the state appoint someone to a public post by discriminating on the grounds of religion? No, because that is something that you can't do. Because Article 16 Clause 2 makes it clear that the state cannot discriminate against its citizens only on the grounds of religion. But fundamental rights are not absolute. There are exceptions. Exception is this. When the state has to appoint someone to a religious institution, it can say that this person who is to be appointed to that religious institution should belong to that religious community, should belong to that religious denomination. So if somebody to a Waqf board is to be appointed, that person can be a Muslim. So qualification can be religion. If somebody to a temple is to be appointed, for that we can say that this person's qualification should be, he should be a Hindu. That means religion can be the qualification for certain jobs when you are appointing somebody to a religious institution. That is Article 16, Clause 5. Then Article 16, Clause 6, which was added by 103rd Constitutional Amendment Act 2019. Now let's discuss this, what is known as EWS reservation. What is this EWS reservation? 2019, just before the Lok Sabha elections, the parliament got together, amended the constitution, and provided reservation for those who belong to economically weaker sections of the society. The parliament said all those citizens who are not the beneficiaries of the existing reservation and they belong to economically weaker sections of the society, for them seats will be reserved. Where? In educational institutions, where? In government jobs. Who are the beneficiaries of the existing reservation? SCs, STs, OBCs. Exclude them. Whatever else is left, members of the general category. 103rd Constitutional Amendment Act 2019, which is known as the EWS reservation, which is known as the reservation for the economically weaker sections of the society. What it says, all those who are the beneficiaries of the existing reservation. Who are the beneficiaries of existing reservation? SCs, STs, OBCs. Exclude them. Whoever else is left, members of the general category. Amongst the members of the general category, those who belong to economically weaker sections of the society, for them there will be reservation. Reservation where? In government jobs, in educational institutions. How much reservation? 10% reservation. This was challenged before the court on various grounds. Ground number one, can economic criteria be the basis for reservation? If Constitution provided reservation for those who are socially and educationally backward, can economic backwardness be the criteria on the basis of which reservation can be given? Number two, by excluding poor who belong to SC, ST, OBC community, are you not violating social justice? Why are you excluding SCs, STs and OBCs from EWS reservation? That's question number two. Third, violation of 50% cap on the reservations. Is it not violative of the Indira Sahni judgment, where the Supreme Court had said that the seats reserved cannot exceed 50%? And if you are providing reservation to EWS as well, which means the total percentage would reach close to 59.5%, which means you're violating the 50% cap imposed by the Supreme Court. On these three grounds, this was challenged before the court. And the court said there is no problem with EWS reservation. EWS reservation is constitutional. Why? Number one, what is the difference between the 10% reservation which was given to economically weaker sections of the society by the Narasimha Rao government and the 10% reservation given by Mr. Modi's government to economically weaker sections of the society? Why was one struck down and the other was upheld? It's not that judiciary is Mr. Modi's bucks and they do whatever Mr. Modi says. That's not the case. Even if that is the case, but that's not something that you can write in the exam. Clear? In 1991, when Shri Narasimha Rao provided reservation to economically weaker sections of the society, that was done by a government order. Government issued an order, government issued a notification and said 10% jobs shall be reserved for poor, weaker sections of the society. When this matter went to the court, the Supreme Court said you have issued an order which violates the Constitution. How? Because Constitution talks about only two kinds of backwardness: social backwardness and educational backwardness. Economic backwardness is not a criteria for providing reservation. So this 10% reservation given by a government order violates the Constitution, as such is unconstitutional. When the BJP government had to provide reservation to weaker sections of the society, Mr. Modi was told, but sir, in 1992 Indira Sahni case, this has been struck down. You can't provide reservation to the poor. Mr. Modi asked the Attorney General, I'm just creating a fictional story. I don't know whether this has happened or not, but this is how you will understand this. Mr. Modi asked the Attorney General, what do we do? Said, sir, I have a solution. Said, what? Said, let's amend the Constitution. How? Sir, Article 368. That I know, but how do we amend the Constitution means, what do we do with that? If Constitution mentions only social and educational backwardness, why can't we change the Constitution and say social backwardness, educational backwardness, and economic backwardness as well? Then even if this matter goes to the court, court will look at the Constitution will say, okay, economic backwardness is a criteria. And that is how Article 16, Clause 6 was added, which says another exception, nothing in this article. What is in this article? That there can be no discrimination. That will not apply. That will not prevent the state from making any provision for the reservation of appointments or posts in favor of economically weaker sections of the citizens, except those clauses, except those citizens, except those classes of citizens which are mentioned previously, which means SCs, STs, OBCs. So, sir, we will amend the Constitution. And when we amend the Constitution, that means now Constitution recognizes economic backwardness. Now, even this was challenged, whether economic backwardness can be a ground for discrimination. The Supreme Court said, yes, it is for the Parliament to decide on what grounds, on what disabilities can it want to provide reservation or benefit to the sections of the people. And if social backwardness is there, educational backwardness is there, it doesn't stop Parliament from adding another criteria for backwardness. And if they have added another criteria for backwardness, which is economic backwardness, that is why 103rd Constitutional Amendment Act is constitutional. That means reservation for economically weaker sections of the society is constitutional. But sir, please listen to me. Said what? What about excluding poor who belong to SCs, STs and OBCs? How can you exclude them? You're violating social justice. Supreme Court asked the government, what have you to say on this matter? Sir, how can we provide reservation to the poor belonging to SC and ST and OBC community? Said, why? Said, they already have reservation. Sir, SCs, all of the SCs, they have reservation. Said, yes. All the STs have reservation. Said, yes. All the OBCs who belong to non-creamy layer, that means they are poor, they also have reservation. Said, yes. Sir, if we give them reservation under EWS quota as well, don't you think it leads to double reservation? Yeah, you are right. See, government is saying it will lead to double reservation. That is why there is logic behind in excluding poor belonging to SC, ST and OBC community. This is specifically targeted to those who do not have reservation right now. Members of the general category, they don't have reservation now. For them, those who belong to weaker sections of the society, they will be provided reservation. If you provide SC, ST, OBC reservation, and for them poor get another reservation, which is EWS reservation, you are providing double reservation. That is something which is not justice. That is why excluding poor belonging to SCs and STs and OBCs is not unconstitutional. It's constitutional. Okay, disperse. Sir, what about 50% cap? Said, what 50%? Sir, in Indira Sahni case, Supreme Court said, you said that reservation cannot exceed beyond 50%. Said, yeah. There we had said something. Said, what? We had said in unusual circumstances, in exceptional circumstances, you can also breach this 50% cap. And today, these are exceptional times. Exceptional times in the sense, 50% cap is not written in hard stone. It's not cast in stone. Situations vary, circumstances vary, and now the circumstances, if there is poverty, if there is poor people are rising, there is inequality is rising, we have to breach this 50% cap as well. So this 50% breach, if it has happened, it is okay, because in exceptional circumstances, we will allow. And this time, Mr. Modi, we are allowing you. Please go ahead. Reservation is constitutional. And the same thing is there in Tamil Nadu as well. In Tamil Nadu, the reservation is close to 69%. And for Tamil Nadu, it was allowed initially. Right now, the case is before the court. I'll tell you what that case is all about. But in Tamil Nadu, the government had to provide more reservation in excess of 50%. When the matter went to the court was asked, how can Tamil Nadu violate the 50% limit? Tamil Nadu government said, see, look at our population. Majority of our population belong to social and educationally backward class of citizens. If we have to provide reservation to them, we have to provide reservation to all of them. But if the majority of the population belongs to socially and educationally backward, that means we have to exceed reservation. That is why we have exceeded it to 69%. Because we have to provide benefit to all of them. We can't provide reservation to only half of socially and educationally backward and remove the remaining half. That is why it should be allowed. And for Tamil Nadu specifically, why was it allowed? That has got something to do with 9th schedule of the Constitution. To understand 9th schedule, we will discuss in Directive Principles of State Policy in great detail. Why was 9th schedule added? What is the purpose? But very briefly here, so that you understand Tamil Nadu reservation, or you understand the reservation, or you understand the demand coming from Telangana, from Andhra Pradesh, from Karnataka, from Madhya Pradesh, from Maharashtra, because they also want to exceed the 50% cap, and they want Parliament to place a law in 9th schedule. Any law which is placed in 9th schedule, there is no judicial review. There is no judicial review. This 9th schedule was added by First Constitutional Amendment Act, 1951. It said any law which is placed in 9th schedule, judiciary cannot question it. Judiciary cannot question the validity of this law. This law cannot be challenged in any court. Various laws were placed, but then on 24th April 1973, in Keshavananda Bharti case, Supreme Court said there is something called basic structure, which no law passed by the Parliament can violate, which no amendment to the Constitution can violate. One such basic structure is judicial review. So judicial review is part of the basic structure of the Constitution. Now the question before the court was, my lord, is judicial review part of the basic structure? Yes. Can Parliament violate basic structure? No. That means, can Parliament pass a law which says there can be no judicial review. Said, no, that cannot happen. Sir, then what about ninth schedule? Said, what about ninth schedule? Sir, law says any law which is placed in ninth schedule, constitution says there is no judicial review. Said, yeah, that is there. So what we will say, any law which is placed in ninth schedule before 24th April 1973, there is no judicial review. Because till that time, there was no such concept of basic structure. But any law placed in ninth schedule after 24th April 1973, there shall be judicial review. And this Tamil Nadu reservation law was placed in ninth schedule. But it was placed in ninth schedule after Keshavananda Bharati judgment. It was placed in ninth schedule in 1990. Now the question before the court was, can you challenge Tamil Nadu reservation law? Court said, yes, we can challenge it because it is placed in ninth schedule, but after Keshavananda Bharati judgment. And even then, the law which is passed, placed in ninth schedule after 24th April 1973, there is still protection. What is the protection? Listen to me carefully. Can a law violate Constitution? Can a law violate Constitution? No. But this law is placed in ninth schedule. And any law which is placed in ninth schedule can violate the Constitution, except it cannot violate basic structure. This is a normal law, an ordinary law. If this law violates the Constitution, this law will be struck down by the judiciary. But if this law is placed in ninth schedule, judiciary can question this law. But if this law violates Constitution, this law will not be declared unconstitutional. This law should not violate basic structure of the Constitution. If it violates basic structure of the Constitution, then this law will be declared unconstitutional. That means this Tamil Nadu reservation law, which provides reservation of up to 69% to weaker sections of the society, to reservation of 69% to the people. This law is placed in ninth schedule. Can it violate Constitution? Yes. Can it violate any provision of the Constitution? Yes. But it should not only violate basic structure. Is this provision that reservation cannot exceed beyond 50%, is this part of the basic structure? No, it's not. When it is not part of the basic structure, that means this law gets protection. That is why Andhra Pradesh, Telangana, Tamil Nadu, Karnataka, they're all saying that we want to extend reservation to our OBC groups. But please place this law in the ninth schedule. Because once this law is placed in ninth schedule, it can violate any provision of the Constitution except the basic structure. And since 50% limit is not part of the basic structure, this law will be saved. That is the whole history of reservation. And let's summarize this. Article 16, it says there shall be no discrimination when it comes to the matters related to public employment. That means only on the grounds of religion, race, caste, sex, place of birth, descent, residence, there can be no discrimination. But this fundamental right is not absolute. There are exceptions. What are the exceptions? Now, reservation is provided for SCs, STs, OBCs, and economically weaker sections of the society. But reservation is not a fundamental right. Reservation is at the discretion of the state. If the state wants to give reservation, it can. If the state does not want to give reservation, it may not. What is the link of EWS reservation? Why EWS reservation was declared constitutional by the court? The court said if previously social and educational backwardness was a criteria on the basis of which reservation could have been given, we can't stop Parliament from adding more criteria. If they have added economic criteria as a ground for reservation, it is constitutional. But this reservation, EWS reservation, it says 10% seats shall be reserved for those who do not have existing reservation, who are not from SCs, STs, OBCs. The court had to decide whether excluding the poor belonging to these SCs, STs, and OBCs, whether exclusion of them is constitutional. The court said if we provide them reservation under EWS as well, then it amounts to double reservation, and that is why it is not allowed. And 50% limit imposed by the Indira Sahni judgment that reservation cannot exceed beyond 50%. This is not part of the basic structure. You can exceed 50% in exceptional circumstances, in unique circumstances. And that is how we have seen extension was given to EWS. Because of EWS reservation, now we have 59.5% reservation at the central level. But then what is the link with 9th schedule? 9th schedule, when it was added to the constitution in 1951, it said that any law placed in 9th schedule, there will be no judicial review. Judiciary cannot question the validity of such law. And various laws were placed in 9th schedule. Matter went to the court. It was IR Kolo judgment. Prior to that, it was Vaman Rai judgment. We will discuss these judgments in schedule as well. But very briefly here, the question before the court was, sir, if judicial review is part of the basic structure, no law of the parliament can violate basic structure, then these laws which are placed in 9th schedule, can you not question these laws? Can you not check these laws whether these laws are constitutional or unconstitutional? Supreme Court said, this doctrine of basic structure was given on 24th of April 1973. And on this date, we said judicial review or basic structure, there is something called basic structure, and judicial review is part of the basic structure. Any law placed in 9th schedule before 24th April, we will not question it because before that, there was no concept of basic structure. But any law placed in 9th schedule after 24th April 1973, there will be judicial review. But even then, this law, which is placed in 9th schedule, it still has some protection. Normally, any law passed by the parliament, it cannot violate the constitution. If it violates constitution, it will be struck down. But if the same law is placed in 9th schedule, it can violate the constitution. But entire constitution has some basic structure as well. This law placed in 9th schedule can violate any provision of the constitution except the basic structure. That is Article 16 of the Constitution. Now, whatever questions you have, shoot. Can a candidate who is eligible to apply under reservation category get enrolled under open category? Yes. If such is the case, then what will happen to the seat under the reservation category? Some other member from the reservation category will get that post. Sir, is it necessary to memorize all this? My dear, if it was not necessary, we would not be discussing. We're not here out of passion. So let's discuss reservation today because I love it. This is required for the exam. Creamy layer is applicable to SCs and STs only at the time of promotion, not at the time of recruitment. Sir, what the court will say in Tamil Nadu reservation? I am not an astrologer. I don't know. I can't know. I won't know. When they will rule on this matter, we will discuss. Sir, you are pure gem. That I know. Tell me something that I don't know. What rights are included in basic structure? We'll discuss that in basic structure. Sir, 16(3) was added in Constitution or originally present? It was originally present. Can we revise polity with tab? Yes. How to remember all these? Revise. Revision is the key. Now, whether this EWS reservation is good or bad, that's the key question that we will discuss now. Is this good or is it bad? Why? Because this is the latest and can be asked in the examination. Good, why? Because this is non-discriminatory. Or should we say a secular law? Why secular law? Because as of now, when you look at SC reservation, who gets reservation for under SC category? Hindus. Because you say there is no caste-based discrimination in Islam or Christianity or in other religions. You have discrimination only in Hindus. That is why SCs are given reservation. So the existing reservation system that we have is basically oriented towards the Hindu community. SCs, or all of them, are Hindus. STs may have Christians and Muslims as well. OBCs also will have Christians and Muslims. But predominantly, this reservation is for the Hindu community because that is where we saw social and educational backwardness. The best thing about this EWS reservation is that it is a purely secular law, in a sense that there is no discrimination on the grounds of religion. That means anybody who is poor, no matter which region you belong from, no matter which religion you come from, you will get reservation. That's point number one. That's the good thing about this law. Second, it will help eliminate the stigma which is attached with reservation. You go to a college, go to an IIT or an IIM, or go to any college for that matter, or go to a hospital, for example, or go to a public place, a government office, for example, you will see that people are segregated. Do you know that guy? Yeah. He's from category. That's why he got this job. That's why he got this educational seat. Otherwise, he was not talented or she was not talented. And then you end up in a fight, brawl. Who are you? How dare you talk to me like this? You are here because you get the reservation. So you treat reservation as some sort of a stigma in the society. Now, those people can also shoot back at you and say, why? Are you not eligible for reservation? Everybody is eligible for reservation. All those who belong to poor sections of the society, they are eligible for reservation. So reservation, there is no stigma attached. We deserve it, we get it. So the stigma which was attached to reservation over a period of time will go out because a lot of people will then become eligible for reservation. And a lot of people today are eligible for reservation. In a sense, that what is the criteria to get EWS reservation? It is same criteria as OBC non-creamy layer, which means your annual family income should be less than 8 lakh rupees. Your family, your father should not be holding any constitutional post. It also means that you should have a property in a municipal area or a flat less than 1,000 square feet, so on and so forth. The criteria, the eligibility is so wide that it amounts to close to 95% of the population becoming eligible for EWS reservation. How many percent people pay income tax? 2% people. 95% people, according to various estimates, their annual family income is less than 8 lakh rupees, which means 95% people means almost the entire population of India is eligible for EWS reservation. So then there can be no stigma attached to reservation. SC reservation, ST reservation, OBC reservation, they will shoot back at you and say EWS reservation. And then nobody will talk about reservation like an evil. It's a win-win situation for everybody. That's the consequence of this law. Third, if you are from SC community, but your father is a minister, your father is holding a constitutional post, or your annual income is in crores, still you get reservation. That means you may be studying in a top school with top coaching, with Byju's, the learning app, the early school app, whatever it is, best type of coaching or very expensive coaching as well. Still you are getting the benefits of reservation. But what about a poor Brahmin who is not in a position to eat food, yet his family is trying its very, very hard to ensure that educational opportunities are given to you, but still you can't compete with a Dalit who has top access to education. So you are creating a situation where after 1991, where economic liberalization took place, rich are becoming richer and the poor are remaining poorer. Oxfam report, which was released recently, and consistently it has said that top 1% people in the world, they control the resources of the remaining 99%. In India, we have the top 40% of the population. They control almost everything. So economic backwardness is a reality staring at our face. And it is high time we recognize it. And that is why economic backwardness is a good identifier, good criteria to provide reservation. These are some of the good points regarding the EWS reservation. But then there are some bad points as well. Bad points in the sense, we need to understand that reservation is not a poverty alleviation program. Or a tool. Reservation is never and was never meant to ensure that people come out of poverty. It was not to tackle poverty. It was to tackle the historic injustice which was given to the members of the SC/ST community. It was meant to undo the wrongs committed against this community. Reservation was about social justice. Reservation was not a poverty alleviation program. So if you say that there are poor who have less than 8 lakhs annual income, number one, this eligibility criteria is so wide that everybody is eligible for EWS reservation, almost everyone. Instead, you could have reduced this amount, say all those whose family income is less than 2 lakhs or 2.5 lakhs or 3 lakhs. Target it at them. Even if you're not doing that, reservation is not meant as a poverty eradication tool or alleviation tool. Reservation is meant to undo the historic wrongs committed against the members of SC/ST community. If you want to remove poverty in the society, give them free scholarship, give them additional benefit, give them free coaching so that they can compete with the others. Reservation, my dear, is not a poverty alleviation program. It is meant to correct the historic wrongs committed against SC and ST community. That's the fundamental flaw with EWS reservation. And that brings us to the closure of this lecture. And tomorrow when we meet, 6 o'clock in the morning, we'll start with Article 17, which talks about abolition of untouchability. Why there shall be judicial review for a law after 1973 judgment? Because after 1973, judicial review is part of the basic structure. And no law can violate basic structure. Please answer my question. Article 15, Clause 4 give reservation for socially and educationally backward classes like SCs and STs in government educational institutions. Yes. 15, Clause 4 give reservation in aided and unaided private educational institutions, and also OBC reservation. OBC reservation was given in 2007. It was provided by a law called CEI, Central Educational Institutes Reservation of Seats Act 2007. 15 Clause 5 gives reservation for those who are socially and educationally backward in government, private, aided, unaided institutions. Lakshmi said, please, you never answer my questions. Lakshmi, when I tried to answer your question yesterday, you had left. So today, whatever your question is, please tell me. Sir, can state reduce percentage of reservation? State can, but then it will be political suicide. That government will lose power if they reduce reservation. You can only expand reservation, but you can't reduce it. OBC reservation is based on the law passed by the legislature in according to the constitution, because constitution empowers the state to reserve seats for socially and educationally backward class of citizens. Because OBCs are also socially and educationally backward, that is why reservation for them. Indra Sahni case dealt with OBC reservation in public employment, in government jobs. Can we withdraw this reservation system? Reservation is at the discretion of the state. If the state wants, it can continue. If the state doesn't want, it can eliminate reservation. How do we learn all the cases? Means we have to learn in detail. Whatever we discuss, you will have to memorize it, you'll have to learn it, you'll have to revise it. Now Lakshmi is gone again. Now tomorrow she'll say I'm not answering her questions. Lakshmi, where are you? What is the final judgment in EWS reservation? Final judgment is it is constitutional. PWD reservation is mentioned in the constitution. No, it's not mentioned. It comes under OBC. Physically different category. It comes under OBC. Having up to income of 8 lakh, don't you think it's a flaw? That's why we discussed, my dear. You are basically giving reservation to 95% of the population. 8 lakh is too wide a criteria. Navneet, what's your question? Basic structure is arbitrary power of the court, so it violates basic structure. We'll discuss that in basic structure, not here. Here we'll discuss fundamental rights. In basic structure doctrine, we'll discuss everything related to the basic structure. Does notes made from tablet videos sufficient? Yes, but it is better if you join the live class, because here we gave yesterday's example, day before yesterday's example. So it's better if you, instead of a tablet, you follow the live classes. Sir, is there any possibility in future which abolishes reservations? Please do not say this at the time of the interview, that we should abolish reservation. You can say that we can enhance it in such a manner so that it reaches the targeted section, so that we can apply creamy layer to SCs and STs as well, so that those from SCs and STs who are left out, they are also able to reap the benefits of reservation. Don't mention the reservation should be abolished. Reservation should continue, but with some tweaks. Okay, that is it for today. Thank you so much for staying with us. We'll see you tomorrow, 6 o'clock in the morning. Till then, have a great time, stay safe, and whatever doubts you have, get in touch with the subject matter experts till 10 o'clock. They'll be happy to assist. Thank you. Bye-bye. Take care.